mean that nye fancy akemene wasa oba ko bi eko nke benye le ni tete TV le anukwale pe jino ni wo fe wo twa wo fa ishi ake wo ba yue ye bi ene ona boni ni emi yo so min pa bu fa ye ishi ba mi mene wo ba kane judgment. Once again, I'm not a lawyer. I've never been to a law school before. I don't claim to be one. I don't claim to be a legal expert. I'm just going to share my opinion. Ni taflache ni biye kume wanyeme ni yoshia ni taflache wanyeko wayako school piye ni moku akalaka wo ni taflache wa afe no kone sa ni woni inko afo no ake anytime ni saneko baba ni eba aje kotu mabomodin ni no ni kotu ba yue nkeba ni nkeba hwe maba makande no ni manye magbla mi ye gami ni obana maboy wo modin kem gbla mi ye gami no ni nye magbla mi ye gami ye ken kan ye blofo mi ye obabo wo ye modin ye get what here. So full disclosure once again, in Yako Law School, J lawyer Jimmy, I'm not playing lawyer on the platform Dabi because in Yako Law School it's a specialty ni me bo nyumo ye so ni mi ni tete in boko na kan nyomo ekwe nye ma tabie ni ma fe to mo eko Jimmy. But then taflache law Judgement. Yes, law Judgement. No ko kande no ko ebie no kande no ko ebie e ba lead ibo ke ya eko ke lead ibo ke te eko e ko kwe no ba kwe e ka gbe ne bo denche o draw o judgment onim shishi whether aye sani ojogba anjo aye sani ojogba anjo. Judges say they are not perfect. They will never be perfect. You understand what I'm saying? Because so sometimes your opinion me they will get it wrong and rightly so. Sometimes I am your opinion me they will get it right and rightly so. You understand what I'm saying? So once again, J lawyer Jimmy, I'm not a lawyer. I want to repeat that for sure. Okay. Ni tabie no ha mi noko ni eba wa ni fe mo ne wa shi au okay if I get Sunday ne be oba fi another episode here mi noko na kan kwa mi shi ba wa Sunday ne wa de nche oh ni tete in Sunday ne all right oh ni sa akani am ye che ni nkwa ko ni mi nwe imbonya blow agani ya machine na ko de kama makwa mi no wache ni ge link send le ese ke ha mi ku wage padi komo no go na mi e ba wa ni fe mo. Anyways, we'll come back to this. That's why in sumo ene you understand what I'm saying? Because of about the sanjiami you know, and these battles boni ni bi etoton ni efite ye wo current dispensation ne mi esani one no fe keke one nana. Okay, you know, be conclude many baba. I never waste time now. But no neke no moji. Shimon be na me ba na ame ba kwe ni ameke femini ameke saga. You understand what I'm saying? So once again, you wala don ake oba. Now, saniye nite no appeals court wabaje. Now, kete of course it will start from the high court. You already know. Kete high court Sempe me winning. They won. The high court. You understand what I'm saying? They won. Of course, now me win here. Alphabet Gbawe. Anytime no ana Gbawe na because Gbawe bi amame won shipon ke alphabet. Ona no one fail Sempe Vrs Gbawe. Amame won na ken shipon jinye ke alphabet. Mind you, Sempe won e won am pi, aflo fly won am pi. So case say short na fail e komi. Bona because kokpaano na kan kokpaano no shout out to Shatter Drake man Jane bebo yojugba mamle o fa ne bebo mu yojugba na fefe komi bona so A versus B, C versus D she fe boli Sempe e won ya me komi Gbawe won won ya me komi no na apele ye bona so case say P na buana na feel e komi na kan like I said high court Sempe winning alphabet Gbawe no shishi alphabet appeal na kete appellate court alphabet ame winning ni no jino ni makane mabo ni lower court ni di high court no ni ame UFN awo achafon sempe no shishi sempe kete Supreme Court na kete Supreme Court be a frame appellate court judgment ni twange alpha beta ke Gbawe be as it stands now when na kan shiko jinye ye amenomi. You understand what I'm saying? Now agbekona I'm sure ke ibaya review nke ete review no ni ba jeje me ba keke ejeje me ba. So no get it a reviewer. It will be more practice and suicidal on the part of Sempe. Keji amekeneke sanene eya review. Ni ama fight ame case. I've seen cases ni Supreme Court a rule in one direction. Ni kakete review at the same Supreme Court no ame chakio. So it will be suicidal for Sempe not to fight this all the way to the end. You understand what I'm saying? It will be abominable. About fight all this thing all the way to the end. There's an akpale. You understand? It's an I may exhaust every single legal means. Ni eye I'm a disposer. Konike amuna kega amuna. And I'm gonna say it again. Kaji niado to tinto. Eani sanene by a review. You understand? For the people of Sempe. Ni waba ya me ba exhaust whatever New York what you understand then it's an akpale ni to get boss Sempe ma blue esane kabie they have another option to fight. You take it, call fight it, no lose way or lose, call winning way or winning. You understand what I'm saying? So it's an new thing to ebomode ni take na can step up and I'm sure he's going to take the step now. Nyefenye na noni te no for those of you ni ekole nyenna kowe week mi alpha beta sanene to be nke ni Supreme Court ye ha me amete no ni amekumokumo ni bi ni amefite ni bi ani wakwe video komekopo pe ye noni banon koni wo bote woni kande momi now nakenjeme keje for a very long time maybe I assume ake Sempe biano niji Akukor Foto shiponji so keji ole at least there are a few judgments come ke rulings come ni ikande yebie ehabo ni ke ashe Akukor Foto obana ke ekole judge ba koti noko ni eba ake ebo ake o ene Akukor Foto Sempe me ano but nibi pi yeshishi bona ni be ole sani say nakanji boni ni ekbaye sani and of course this appellate court ruling Supreme appellate court judgment Supreme Court judgment ete nibi pishi ehami ni ehani injomo ete nibi komano ni hiretu nomie injomo eyakono some of the cases komeni inlay. You understand what I'm saying? Inlay. But this very one, ekbele imekete jeme wa dienche. So, like I said, it is good at these cases. Fe yanobi ane bonia fe ni yinobi konklomeni baba. Ameka waste time. Boni lawyer foi eye washika efa. Boni judges eye washika efa. Now, they may not always get it right. The courts will not always get it right. I'm a ton da. You understand what I'm saying? But at least, KG, I exhaust every possible legal means ni you're available. What's a you know be concluding baba. Afite shikafi you and ni aba no ni lawyer foi. Ubana lawyer nyoko. Aklowako a lifetime fair a law school in Ghana. In 5 years time no be no bana ema mansion. Meanwhile mancheke wokume amenya mansion. I mean, you washika so you know be concluding baba ni ame drink ni shipon no fe no ni ame ba na ka ma me no ni no ni ame ba nya ame kefe ni ekwa wa ame mambi ni amenye ame kefe ni ekewa ame mambi. You understand what I'm saying? So I love these legal battles. It is very, very important. I love reading them. In ya law school boni inya kwele tawo egole dote ba mi ni ya law school ale no ma kwele mejigbe teni ngele ngbaza ne ngela ge mani bu e ka segbe law school ekole onabi dote ba ye habo nyani wakwa ni bi ekome no so akumokumo ni be based on the judgment ni tumobani nkobo alpha beta ena Supreme Court video eko ne matwe nepe ke ona ni bi na akumo of course wajin acheme kome ajejeme ni ayame ni apply ame ke ni bi you understand what I'm saying. Unless they conclude themselves that the judgment is actually correct. So there you have it. So like I said, I think we will do a part 2. Now, what I say part 2, once again, I'm not a lawyer, but can any come mahabu ni what go outside of the judgment because in a case is meaning baby and no what you make me last week ne come enemy ibawabo she inquire me because of course be an ne kai me war or I feel na can part she only the Sempes too always rely on akolache judgment ni claim na kan jeme but kayadwade crab benino kone jekwe nkata nunu ngbasani nkaya bache ngbasani ni nkaya bachage akolache kewake neke state farms ne sempe ejimoni eke ha government so nakanjeme for a long while I have always known based on nakanibi any kanye ake nakanjeme sempe me ashipon ni no ni jenyo I've seen quite a few cases come even just recently ni actually ni danso ke sempe te court judgment telling to go in kanye there was actually a portion who ni judge make reference to ake Akukor Foto land say Sempe mano I think once again ke gwa ke court tell sanie beno ko ya evidence do ko ba ya na kanji boni abayele but unbeknownst to me that akola judgment podi enje ke okanelo jugba they actually ruled against Sempe from appellate court judgment now naken judgment term and I'll show you all of these documents in Kobo in Kwachombo the 3rd episode then what in Kwachombo naken judgment there was a case ko ni judge make reference to ake Sempe me a rule against me and I think obana eminoji I can case I can case obana ke judgment then ni makani abu no yemi judge make reference to ake efe Sempe ma na pe no ne woni ame appealiko na kan I can case na kan I can case e call na kan jame gbe no a rule in favor of Gbawe so na kan rule in any Gbawe bi enye ni Sempe me appealiko na kan rule in na kan no ni Gbawe bi domono no ahun ni ball ameke ho na kan jame she kon gfe now why ni Sempe appealing like I can rule in it at the time kebatabi I don't know now I don't know if the statute of limitations still ni I may appeal like I can rule in it I think I can rule in it happened in 2006 or so eche so why ni Sempe appeal if like I said ke okwe the Danso family ke Sempe stool any appealing like jame egbe ekwe judgment judge lenche fele na akpe I rule against me and kebi na no still I may appeal ko judge make reference to nakan case and nakano I think it was very bad legal move on Sempe why ni Sempe appeal nakan judgment you understand what I'm saying because nakan no ni Gbawe edomo no auni boli ame ho nakan jame shipon gfe now no penny. Of course, their case now I'm a presenter that there are other things coming I make a war me. You understand what I'm saying? So like I said, but it was legal more practice. Nis no one is Sempe appeal because I may appealing like a judgment and case in a ni ekole in their favor but they didn't do it. I agree with what you are saying. I've actually cited something and and I think I get no because I may rely on Noko ni I may fail yes say. You understand what I'm saying? And they thought I can know be eba wame. Ona nike I'm fair me ake be I'm challenge you don't be akba wajeme. You understand? But of course, Bawebi did not. They just went ahead and I'm a feno na me bafi. Now, Sempe me le wa ma me won shipon GP again I get come 1 billion can be video come in now na chair me can be. You understand what I'm saying? So like I said, I will do a third episode. Ni nekendi bi na come fe makande kande mahabu keke onu shishi ojogba de nche. But because I alomo ni apply me ni ayi me insumo ni wanye me ko me ba ya je me ko ona ni ame ba alomo alo ame ba ya na ba yiyi ame ko, and that is why I always want to do this. You understand what I'm saying? So about it na kan sanjie me like I said, Akolache Judgement, it's one thing is Sempe me dumono now Akolache Judgement, what Akolache Justice did ejake e blash ko GFN e chon ko she be ne ma no ni Akolache Judgement mi polenche e ko me ke look, we've always known that the poultry farm was given to the state, the poultry farm land was given to the state by the Sempe too, but a challenge in Akaino niji Gbawe I'm a challenging I can know lenche Sempe me chon be papano. Once again I am not a lawyer. You understand what I'm saying? Hopefully Alaji Nkwewo ke Alaji Nkwewo ke wakandi atan kele babano koni eba she, you know Alaji a legal expert ni eba chon wo no ni ena yeneke Sunday name. So I'm just going to read bona koni what move on koni what nu sanjie shishi ojogba wo makande Supreme Court no mabo jani femo kiamoko no kiamoko ni wabotemi ni moko akemoko boni afeka moko te se na akele no gweka laga dabi je na kanji boni angma e wolo emi je na kanji boni judge say ke. You understand what I'm saying? And we will do this in kebagami case be jani ne eko ni ne share no scan in the share no. I don't care who wins or who loses. One tower no kwali ayinshi. One tower, you know, be conclumini ba I'm a mindset achake, and that is why we do this. So ona nibi ekome, and of course ona te achole te mina achole what do you call it? Me na jiji ke nibi ona na kind of thing. So I'm not gonna play that. Now we'll move on. Ni wakanya noni te achole te appellate court ke. You understand what I'm saying? Ke agbene what make progress. So that's what we are going to do today. Once again, min ke boake J lawyer nyojimi in yako law school over ine ka kemu gwake ni tete ike limla dabi. I'm not a lawyer in yako law school. Nke wage me bo nyomo ye imboko naka nyomo eko inko naka no ke phone no. I don't know it all. I don't understand it all. This is just going to be a man reading of the law. Ona bonini yo. So ofine call na kan oami onu. Now, so let's go. So tumobeni nkebwe because shipon Sempe stool hon eko ame keme wo alphabet ke Gbawe ka men siwe ni Gbawe hu alpha Gbawe hu trala ke alphabet no ke asiwe of course ke two plots ko ebie ni ebaje no ni Gbawe hu alphabet mi alphabet ma me siwo mo bona. So short and all of these people who ameba defender me as defendants. You understand what I'm saying? In Kebwake agency High Court Sempe won alphabet anunshi because I'm Gbawe. They took it to the appellate court. I'm a winning a appellate court ruling there. No junior ni makani abwe ni ajejeme at the Supreme Court. Na se Supreme Court Supreme Court affirm noni appellate court ruler. So as it stands now, that section of the land belongs to Gbawe, and in essence, Alpha Beta. You understand what I'm saying? As it stands now, Sempe Benoko Ejeme. That's why I mean it will be more practice. Ni esani actual Sempe me ke otinto ni adoto tinto e ke ni ne ya review. You understand what I'm saying? Esani Sempe me adumono na ke pale. he has to take it up. In that cases, the Supreme Court no, and by one direction, can't review it, and can't make another direction. So can you think to a fe na Sempe me, if you are going pale, a bonya blow, scare fe na bebo modi, benitrage really is fighting for your interest. And of course, I believe noji noni e bafe. Now, you know what? Let's do this. Before any about kind of judgment, nimi we ni tinto sande, it will only be fair. Mani ona noni ewe ye neke sande nehi. Ke wagbena huwe makande noni Gbawe biya unwe. Ke agbene wabote sande mi. Bona boni ni yo. So as it stands now, keji oye mina chole oye Sempe ni tinto is fighting. Is fighting. Is fighting. So anima kane noni Sempe stule ewe ye neke noi eke ka wagbena waba kane judgment oduba ofane jani fe kiamoko no kiamoko naka inliage manchema sande nyesumo ene fe fitai fe fita manchema sande so bomode kiamoko no kiamoko ni eba bono na kan yo twe boni afe ni moko agala kale ni ehe naka lakamo awoni. You understand what I'm saying? So noni Sempe stule yue after ni nekeno kone ewe ani makane mahabo. Once again, to my bonning kebwe okumamuko no kiamuko. So I'm a release letter there 16 February 2026 to the Inspector General of Police Headquarters, Accra. Okay. Urgent petition concerning unauthorized demolition of properties, physical assaults, and police misconduct at Akukor Foto, Freedom Village, Sempe, involving ASP Osafo Boachi and personnel from police operations headquarters. So once again, this was a petition they wrote to the IGP. Koni ame investigate no need no ni police for national security BG me. Let's go on. They get preamble. Okay. So we, the Sempe too, as the custodians of the traditional authority and heritage of the Sempe people in the Greater Accra region, humbly approach you with this petition in the spirit of our shared commitment to the rule of law, the protection of vulnerable communities, and the sanctity of judicial processes in our beloved republic. This petition is submitted without prejudice to the pending judicial review application filed by the Sempe too before the Supreme Court of Ghana, scheduled for hearing in March 2026 concerning a judgment dated 17th December 2025. So here you go with the news. So Sempe actually a filing for review. So there you have it. You understand? So Sempe me nyakakpa ni otinto a filing for review. Abaye in March 2026. So after any judgment in December of last year, I may apply for a review. Ni abache in March of 2026. So once again, there you have it. That's the news. Wherein Alpha Beta was granted possession of approximately 12.9 acres of disputed land at Akukor Foto, situated within Freedom Village under Sempe jurisdiction. So once again, Sempe me amekete review about March 2026, and that is why you can tell I'm a petition because keke say a review. But once again, okay, so we'll get the lawyer to explain. And the KG Supreme Court ni I know it's a review and a stop or the judgment at the time until ni review allow many may receive judgment in their favor. They can actually go ahead ni ameba execute no niya ha me. So obakwake alaji ye bielo abache ofane penny more let down am yonu ni ka alaji ba. That should be one of the first questions. No babile. Now, our sole intent is to draw your urgent attention to a grave incident that transpired on Friday, 13 February 2026, which has caused immeasurable distress, loss of property, and bodily harm to lawful occupants and residents of our community. We bemoan the blatant disregard for due process in this matter and express our profound dismay at the conduct of certain police personnel, which has not only undermined public confidence in law enforcement, but also exacerbated an already sensitive land dispute. We respectfully disdain the overreach and apparent complicity in unlawful acts as detailed herein and implore your office to intervene decisively to restore justice and prevent further escalation. Let's go to the next page. Number 2. Brief background to the dispute. The land in question, comprising 12.9 acres at Akukor Foto in Freedom Village. Let me make it a little bigger so you can see on your screen as well. Has been the subject of long-standing contention between the Sempe stool, private residents, and Alpha Beta, following the aforementioned Supreme Court judgment granting possession to Alpha Beta. The Sempe stool, in exercise of its rights, promptly filed a motion for review and is slated for hearing in March 2026. This pending review underscores the necessity for all parties to exercise utmost restraint and adhere strictly to legal protocols, including obtaining requisite court orders and administrative permits for any enforcement actions. Regrettably, the events of 13 February 2026 represent a flagrant violation of these principles, extending far beyond the scope of the judgment and inflicting undue harm on innocent parties. Facts of the incident. So this was clearly written by a lawyer. Excuse me. On Friday, 13 February 2026, a contingent of about 19 police personnel from the Police Operations Headquarters, led by Assistant Superintendent of Police ASP Osafobuachi, arrived at Akukor Foto under the ostensible guise of serving the Supreme Court judgment on the residents and occupants of the disputed 12.9 acres. Accompanying the police were a group of irate individuals identified as workers and associates of one Mami Sarah, the daughter of the proprietor of Osamampan Properties, the entity that purportedly sold the land to Alpha Beta. So, let me explain. So, Gbawe Bia na me on shipon, I me on Alpha Beta directly. I me on a real estate agent ni achame Osamampa Properties. So, it was Osamampa Properties ni ame hon na kan shipon Alpha Beta, right? So, Gbawe did not sell the land to Alpha Beta directly. They sold it to a real estate business ni achame Osamampa Properties ni jime ni ame hon kaya Alpha Beta. Excuse me, let's go on. What was purportedly a routine service of judgment swiftly devolved into a rampage of destruction and violence. Unauthorized demolitions. Bulldozers and heavy machinery were deployed to raise several structures, including residential and commercial properties belonging to private residents. These demolitions extended well beyond the 12.9 acres delineated in the Supreme Court judgment, encroaching upon adjoining lands and properties owned by lawful occupants who were not parties to the suit. So this is something that Sempe is saying. Okay, judgment I don't know about it cover only 12.9 acres. Shimon, demolition any abafair, it went beyond the 12.9 acres. If this is really true, then outside of the review and Sempe file, they actually have another case. They should file a separate case completely altogether. 12.9 acres sanipe ayuo ni meni meba ni ameba kumoma ni bi ne it go beyond 12.9 acres. Then Sempe has another case different from noni waya name, because you must stick to the noni law. Alo mla, alo sanye na yo, noni detector. You cannot go beyond noni court by authorizable. It belongs to you. So Sempe should be filing. Maybe they have done it. Maybe I'm inlay, but they should be filing a separate case altogether. If really it is beyond the 12.9 acres. You understand what I'm saying? Maybe I'm and Wabana one way. Now let's go on. Encroaching upon adjoining lands and properties owned by lawful occupants who were not parties to the suit. As subsequent inquiries, corroborated by eyewitness accounts and preliminary assessments, confirmed that no demolition order was issued by the Supreme Court. They have once again case in Kebwakame yo Keji Supreme Court a order ko Akeshi demolish. That's what they are saying. And we'll go into the Supreme Court judgment. What about me? Ni what the Supreme Court take what about me? I'm not going to tell you now, but we'll go into it tomorrow. Koni bodencha onu kenhoyi. Keji lele the Supreme Court hako ake demolish manibi yeme. There was no enforcement order attached to the judgment. Then that's another thing. Was any demolish was issued by the Supreme Court, nor was any demolition permit secured from the Blekuma West Municipal Assembly, as required under Section 79 and 80 of the Local Governance Act 2016, Act 936, and relevant building regulations. So once again, I'm in code law. Get about demolish muko building there. So no a permit from the Local Governance Act there. Municipal Assembly then I can build in there. Yo, so no a permit. I can permit Supreme Court order once again. They have a case outside of noni ya no because it's completely different. It go beyond the 12.9. They have a separate case. I'm filing. Physical assaults and battery. In the course of these operations, the aforementioned irate thugs, acting with impunity and under the apparent protection of the police presence, physically assaulted and battered several lawful occupants whose properties lay outside the 12.9 acre boundary. Once again, this is a case Sempe is making. Bene ame file yomo. I don't know in the second, but like I said, if somebody goes beyond no court, that's a case. You understand what I'm saying? Some residents attempting to protect their properties became victims, reported being beaten with sticks, fists, and other improvised weapons, resulting in injuries ranging from bruises and lacerations requiring medical attention. This assault has been reported at the Dansoman police station. And yes, and these individuals say, I'm a properties follow outside of the 12.9 acre boundary. I'm a personally, I'm buying individually, I'm buying, take these people on, sue their asses. You understand what I'm saying? You need to sue the police service, sue money army, order, sue everybody's ass. You understand? And so they should get lawyers. They can go for individually, whatever they want to go, sue them. Really, they've gone beyond. Sue their asses. Okay, let's go to the next page. Awaje, ofane ina in screen noise. Ofane kenokwe, ofane animally onu. Okay. Okay, let's see. Okay, NFA. Okay, so let's do it this way. Police publicity and overreach. ASP Osafo Boachi and his team of about 19 police officers, rather than maintaining order and ensuring compliance with legal safeguards, willfully condone these excesses. You find it because in Zoom layout there, it blare out nibi man so knowledgeable. So if I BBO your screen, no arrests were made. Despite all right, page number 3. Over an animal can your phone a better screen can be nagage inchiketi any obana layer. Okay, so that's page number 3. Hey, bien and ye Oh, okay. We're going to struggle with this particular page, but let's go on. No arrests were made despite the clear commission of crime offenses, including unlawful entry, contrary to Section 114 of the Criminal Offence Act 1960, Act 29, destruction of property and assault. This conduct not only failed to uphold the Ghana Police Service mandate under Section 16 of the Public Service Act 2020, Act 1054, but actively abetted a breach of the peace in a community already is it reeling from judicial uncertainty? Because it blurry be I cannot see it anymore. Let me put it up. We further disdain the conduct of ASP Osafo Boachi and the involved police officers, which fails woefully short of the professionalism and impartiality emblematic of the Ghana Police Service. Such actions evoke memories of past abuses that our democracy has strive to eradicate, and they demand immediate accountability to reaffirm that no one, not even in the pursuit of the court judgment, is above the law. The irate thugs masquerading as enforcers must be viewed as perpetrators of organized thuggery, potentially constituting a breach of public order. Their affiliation with Osamampom Properties and Mami Sarah raises concerns of private interest hijacking state machinery, a practice antithetical to our constitutional order. Me struggle because and number 5, our humble prayers and demands, and the interest of justice, equity, and the restoration of peace, we must respectfully pray your high office to A, institute an immediate, impartial, and thorough investigation into the events of 13 February 2026, including a full inquiry into the roles of ASP Osafo Boachi, his team, and the irate thugs, with a view to ascertaining culpability and preventing recurrence. Order the prompt arrest and prosecution of the identified irate thugs for offenses including assault, destruction of property, and unlawful assembly, ensuring that justice is meted out without fear or favor. Deploy neutral police personnel to secure this area and maintain order until the Supreme Court review is determined, thereby preventing further unauthorized incursions. Now I have final page. Okay, what can they noni that will be a release? I'm a statement. I'm on conclusion. Sir, the Ghana Police Service stands as a bulwark against anarchy, and we place our on something faith in your leadership to uphold this noble calling. The people of Sempe, resilient yet aggrieved, seek not vengeance, but vindication through the scales of justice. We are confident that under your stewardship, this petition will catalyze the accountability our community deserves, thereby honoring the oaths we all hold sacred. We remain available for any discussions or clarifications and enclose here with digital copies of the judgments and video clips of some of the demolished properties in support of our claims. Thank you for your urgent attention and anticipated swift action. Yours faithfully, given under my authority, Ni Adote Utinto II, Paramount Chief of Sempe Traditional Area and Mankralo of the Ghana State. There is nothing called Mankralo of the Ghana State. Ni Nakainole Dabi anytime ni mana mayui abeno gona chole Mankralo of the Ghana State. So Nakano get your GMO. Now, ni Sempe be a release any once again. Gbawe bi amenmawolo You understand what I'm saying? Ofane jani femo kiamoko ni okiamoko tumoboni nkobwe ni waba ni boli waya yin shemo waifako kula waifako topic wo abaka ni sumo ni kan mo nge fe na kan ege alakaje ega ni nyete nyen no fronji ni eja. So Gbawe will release a counter statement to Noni Sempe Vrs. Now, let's go on. For immediate release, 18 February 2026, Gbawe Quarter family responds to false land ownership claims by Sempe Stool and incidents at Akukor Foto. So, let's go. The Gbawe Quarter family wishes to formally inform the general public of recent unfortunate developments arising from false land ownership claims by the Sempe Stool over the Akukor Foto lands, traditionally known as Gbawe Konyo Na. I hope I did not butcher the name. So Gbawe biye ameka Akukor Foto land ame choje me Gbawe Konyo Na. Gbawe Konyo Na. Let's go. The family strongly condemns the disturbances and acts of mayhem allegedly associated with attempts to challenge the lawful activities of Alpha Beta Educational Center Limited on the Akukor Foto lands. We state unequivocally that all actions, including demolition exercises undertaken by the said Alpha Beta Educational Center Limited, were carried out pursuant to lawful authority and grounded in binding judicial decisions of the courts of the Republic of Ghana, including affirmations by the Supreme Court. Let's go on to the next page. Now, so you have Gbawe. These developments follow recent agitations and attacks on security personnel and court officials by the Sempe Stool. So this is the counter allegation. Now, I make anytime need security personnel by Ajame, low court officials by Ajame, Sempe Stool attack on me. During which assertions were made purporting custodianship and ownership of Akukor Foto and adjoining lands. Ownership of Akukor Foto and its adjoining lands has been conclusively determined by courts of competent jurisdiction, including A. Concession Inquiry, number 1076/56, 20th November 1956, Supreme Court of the Gold Coast, Eastern Judicial Division, Land Division, Gbawe Clayfield Concession. You call your Clayfield Concession, what way some of the, you already know. Land Acquisition Case number 253, 31st January 1955, Waterworks Pipeline between Wager and Odoko, Supreme Court of the Gold Coast Land Division. Neken no kone nakan Waterworks bi ani ne ke okane and it really Akukor Foto shipon GN fitai. I have that here. I will read that for you. Like I said, we'll do a part 3. Some of the cases komene jaja in the case because I don't know, maybe in Kandekolojuba, but I don't know. I can wage anoni court determine I can Akukor Foto. But once again, we'll bring that up for you to know. Consolidated High Court and Court of Appeal decisions, including Ni Adote Obuo II versus ICAM Limited and 4 others, suit number L.215/2001. Ni Adam Kwate versus ICAM Limited and 2 others, suit number AL.23/2003. Civil appeal number HI.215/2009, 5th May 2009. All right, let's go to the final page. Alpha Beta Educational Center Limited versus Reverend Mama Mercy and 10 others, and Alpha Beta Educational Center Limited versus Nana Osei Bonsu and 9 others. Civil appeal number HI.119/2022. In its judgment concerning the Akukor Foto lands, the court held that the traditional evidence adduced by the Gbawe Quarter family was credible, probable, and unchallenged. You got it? The court further found that Akukor Foto falls within the larger tract of land belonging to Gbawe and the Gbawe Quarter family, had established a better title than the Sempe stool. Accordingly, the claims of the Sempe stool were dismissed. Furthermore, in a decision dated 23rd July 2024 in Civil Appeal Number HI 119/2022, His Lordship Justice Henry A. Kofi, Justice of the Supreme Court, reaffirmed the status of the Gbawe family as the allodial title owners of Akukor Foto, Gbawe, Otojo, and surrounding areas. For the avoidance of doubt, any representation to the contrary by the Sempe stool is false and misleading. Additionally, historical suits cited by the Sempe stool, including Akolache suit number 72/1948 and the 1963 judgments, do not relate to nor affect the proprietary interest of the Gbawe Kwate family in Akukor Foto, Sakaman, and adjoining areas. Is that it? Do I have another one? Okay. So I think that's about it. 1, 2, 3. Okay. Yeah. So noni Gbawe bi pretty much I'm a kid. But so ni Sempe me release a statement. This was the counter argument ni Gbawe bi make. Shout outs to you. Akuche Bafita way. Shout outs to you, Man Beatrice. Like I said, Johnny Femo. Shout outs to you, Ted Ajay. Shout outs to you, Nishipi. Shout outs to you, Dave Eason. And shout outs to you, Manye Na K2K. Now, managing ni appeals court ke. Nyani wabote ami. Johnny Femo. Kiamoko no kiamoko. Kemo la keba butwe ni tete TV. Ni sumoni moko ba ya ni aba ajile. Ni ke ajile ni se mi ke afe no ko ye. Enase because lemon eba fe moko ni e tomla. You understand what I'm saying? So o fine Jani femo ni okiame ni amebabo no ni call to yetwe hami gonti no ni ya nwe ke link anwe Facebook share mo to the WhatsApp groups no yo efen no yo kegme jeme nya woboti ami in statement no ni Sempe bi eke am statement me e abo background e fio nkan Gbawe bi ano nya woboti a no ni JJ, hello, Judge say we. Yeah, shout outs to you, Uncle Charles. Yeah, appellate court. To my being careful, war or back on the Supreme Court now. Then we'll do another third episode with different court rulings, judgments. Ni a cover, ni ke be no, na kan jame be no, ni okwake ani judge say if a justice to the case no. In one nake ni Sempe a file to the Supreme Court, ni a review. Take it up to the review. Would have been more practice. Nishuku make Sempe make amekpale. She FA na kind know ekete review. Koni a review. Like I said, I've seen the Supreme Court rule in one direction. The same Supreme Court no kakete review they will rule in another direction. So agbekuna Sunday na agbekuna until abaye review Sunday ata ke obebi en kan no abaje review March. Abaya review March 2026. Niji next month, you know. Now what on here? Noni. JJK. So there you have it on your screen. I hope I can no fair no you clear ni ida ojugba. Yep, it appears so. So presiding judge Henry A. Kofi Leno P.A. Bright Mensa ke battles kojo message so nege and Renee, Justice of the Supreme Court, Leno is sit as appellate court judge, which happened between so come on consolidated case is come on between Alpha Beta Educational Center Limited, plaintiff ke appellant. So to mobeni kebwe Alpha Beta amamekete appeals because na kete high court Sempe yame. So amamekete appeals. So ameji plaintiff ke appellant versus Reverend Mama Mercy and 10 others, defendants/respondents, and Alpha Beta Educational Center Limited versus Nana Osai Bonso and 9 others. Once again, defendants/respondents. Bright Mesa Justice of the appeals court. So now what Janshi? You get a plaintiff. So anytime nobody know the plaintiff/appellant, but I refer to Alpha Beta. I mean. Hearing simply referred to as the plaintiff has launched the instant appeal against the judgment of the High Court. So, Sempe me win your High Court to obeying minta no ni should ba repeat. Sempe me win your High Court ni alphabet abi enu shishi no ama make the appeals court Accra Land Division delivered 5th of March 2021 in consolidated suits numbered LD/0794/16 and FAL/558/14, respectively, tried by the said court. The judgment appears on pages 77 to 114 of Volume 4 of the Records of Appeal. And apparently dissatisfied with the decision of the lower court, the plaintiff has filed the instant appeal on a number of grounds, namely, the trial judge, after affirming that the plaintiff was entitled to a declaration of title to disputed land, erred in not granting the release of possession. So many grounds are make here. Okay, even though nakan sandi me, even though Sempe be a year, je me ake nakan jame alphabet be they are entitled ni abanya am a title to the land. She money you a grantee, even though you nakan. Number 2. The trial judge erred by holding that the defendants were in possession of the land. Mo ake alphabet abanya have a title to the land there. It can harm and we no eteno ne yuake defendant say in this case and I'm a yon case say me amame they possess the land. Beshipon amame noni so ni be a basa. Now the trial judge erred when he dispensed with the composite plan which had been drawn to aid the court in arriving at a just judgment. Literally, a composite plan ni akete trial judge ekweno ni ebakwe ni ebawa esane yeli composite plan you know what it is. I draw in a few be meneno wa be neke be neke na be meneno fe neke meneno fe neke judge ekweno ni ebawale ni eyesane ojogban eche afon. Now, too much. Well, back then I know a dollar we won in Kewaga 48 pages. She far. Yeah, I was done reading in about 30 minutes. Maybe it's because I didn't have to stop and talk about it, but by 30 minutes, back in I was done. Number 4, the trial judge erred in holding that the Yaoduade case, in which judgment was given in 1963, granted possession of Akukor Foto lands to the Sempe stool. Neke Yaoduade ne leunke waka ye dan soma ke Sempe sanene achita. So Sempe, they actually have quite a few cases komeni. I'm mentioning explicitly Akukor Foto land say it belongs to the Sempe stool. They actually have cases, and no many I may rely on no niboli. They keep claiming but nibi p. Now, number 5, the judgment was against the weight of evidence. Nibi ni shwe judge decision ni arrive at evidence chiefly ni track evidence ke follow evidence na ke ba isani chile to another direction. She consider no further grounds of appeal will be filed upon receipt of a copy of the records of proceedings. Now, see pages 115 to 117, volume 4 of the records of appeal. So far, the plaintiff has never filed further grounds of appeal. Notice of appeal by defendants. Significantly, we also have on record a notice of appeal filed by the defendants describing themselves as defendants and counter-appellants on 24th September 2021 with a leave of the lower court against the judgment of Amoyate J, the same judgment the plaintiff has appealed against, complaining that so defendant said appeal, even though nakanote in their favor, they are also saying nibi komete no ya nakan judgment no mi ni ameu ametao engo amena no amo ameke sani amba appeals court ni judge ekwe ni straighten nakano. So obana ni alphabet and kake judge they are entitled to a title of the like abanya fe title ye shipon okay hame bona the same judge no it gets many men now shipon they possess that land, so it's a little contradictory. You understand what I'm saying? So defendant say no na mama appeal so enyo ama me get abi onyo kake wa possessor land there be shimo in the same breath o kake this other party is an a title to some portions of the land. You understand what I'm saying? You cannot. So I'm appealing ni any offense. So both of them were fighting. Ni I'm a fan, I'm a kete. I'm here. Let's go on. The judgment is against the weight of evidence. I'm going to get the same thing. Nibini ameke shwe judge yeke e kwele ojugba ebachi into a different direction than noni ekeba. The learned trial judge erred when he held that Akolache J's judgment of 1963 covered the disputed land, and yet stated that the plaintiff was entitled to a declaration of title to the disputed land. No, you know, he explained Yabo before in Kandie. Number 3, the learned judge erred in that after affirming Akolache J's judgment of 1963 in the Yaodoade case, which granted possession of Akukor Foto lands to the Sempe stool, proceeded to decree title in favor of the plaintiff. So tomorrow in blame no, how can you say ake shikon menemano and in the same breath of ake the opposing party a title to the land? Naka no blame abu yagami before punkanye. The learned trial judge erred by holding that the plaintiff was entitled to a declaration of title to the disputed land. Number 5, the learned trial judge erred after holding that after holding that it does not have the slightest power to deviate from the decisions of the Supreme Court per the hierarchy of court, as he is bound to follow the decision of the Supreme Court, failed to depart from Ofoi's judgment of 2006, which had declared title in the disputed land in favor of the plaintiff's grantor's predecessor. Once again, so you can understand, Kaji okwe akola cheke ya oduade no kake ye naka no sempe bi ano naka judgment na ka abo no emie te fiote ni kemoko judge conclude ewie no ko ni naka judge lower than what the Supreme Court has decided there ni obakono as against no Supreme Court decide. Additional grounds of appeal may be filed upon receipt of the record of appeal. See pages 120A to 126 of volume 4. For purposes of this appeal, the defendant/appellant shall also be simply referred to as the defendant. So let's go on. Key background. Having regard to the complexity of issues in the consolidated suits, both on the facts and the law, it is not only prudent but appropriate to set out in proper perspective the facts and the pleadings the parties filed on record and the events leading to the judgment complained of. So abanaba chombo nibi na file efen ke nibi nikeneke eneme femba. So nya wabotian. Hey. Where? The first suit number FAL/55H/2014, Alpha Beta Educational Center Limited versus Nana Osebonso and others, per writ of summons issued in the registry of the lower court on 28th March 2014. Alpha Beta Educational Center Limited initiated the first suit number FAL/55H/2014 against 5 persons, namely, so Achombo any Sunday from 2014, Nana Osebonso, B, Mr. Frimpon, C, Mr. Abuaji, D, Mr. Hiaji, and E, Madam Rebecca, claiming the following judicial reliefs. A declaration of title to all the piece of part or parcel of land in extent 5.20 hectares, 20.85 acres. Okay. More or less being parcel number 4, block 15059, situate out South Odoko Estate in the Greater Accra region of the Republic of Ghana, aforesaid as delineated on the registry map number 004/059/1991 in the Land Title Registry, Victoriaborg, Accra. Let's go on. B, recovery of possession. C, damages for trespass. D, perpetual injunction to restrain the defendants and their assigns and privies and workmen from trespassing on the plaintiff's land. The defendants entered a joint appearance through a lawyer, Kwesi Ajenim Boateng. The notice of appearance appears on pages 15 to 16, volume 1 of the Records of Appeal. In response to the plaintiff's claim, the first to fifth defendants filed a joint statement of defense that appears on pages 29 to 32, volume 1 of the Records of Appeal. The defendants denied substantially the plaintiff's claim and accused the plaintiff of fraud, the particulars of which are reproduced here below. Particulars of fraud. So, alpha beta, now make a you understand what I'm saying? There was a counter, meaning accuser, Wojena me your fan, I may acquire through fraudulent means. You understand? Let's go on. Particulars of fraud. The plaintiff knew that the first to fifth defendants were in effective possession of their respective lands with their property thereon. Yet the plaintiff concealed this fact from the office of the Lands Commission and succeeded in obtaining the supposed land certificate. So I make a plaintiff anytime no plaintiff allo appellant you alpha beta. Ni ametena my title to a particular land there. I'm a Malay lands registry. I make a lands registry. Ake shipon me come normal ni ame mamo ni bi no. No nakano fraud ni do beno amechon. In their statement of defense, the first to fifth defendants counterclaimed against the plaintiff as follows. A declaration that the first to fifth defendants are the owners of their respective lands described in their deeds of indenture given to them by the Sempe stool as contained in the schedule below as first to fifth defendants' land. So, nichwanke, mino ame kona ka ake indenture ni amenye shipon no Sempe bi eke hame ni efele clear ake na kan shipon ama amenoni ame deed ke indenture ni chwanka ama ameno ne woni aile cheko wada na ke oye shipon mukodi ni ambo indenture agbekuna. What you need to do is actually go yourself and do a search before I pay no fair no time. Go to the lands registry and do a search. Nyo kwake money ambo na kan indenture ani na kan shipon le no ni lo indenture follow it doesn't work. You understand? And so wafeni wa yo man say wa ka se ni bepi ka woni ne she indenture no ka wajeme bona ka indenture abu alo ka indenture chonbo don't no your lands commission ni oya search ake na kan shipon ani money ambo indenture shipon ye le igbe mi lo. You understand what I'm saying? So when many wa man say wa na ne kesanji no jugba most of the time nya wa ka fi ani kasemo indenture de no pe indenture echon moshiponche. Have that at the back of your mind. Indenture echon moshiponche. You understand what I'm saying? So kamoko abo indenture ya lands commission no ya fe search ni achobo money owner title to the land. Nya woke kasiani wo man say bi ne ene emo wa ade enche. Woke kasiani wo ya lands commission no wa fe search. Nya wo fite shika ni woke fe search ba wa in the long run. You understand? Because keshikpo moko no ni no ya ba ni obaso ba shikpo ekon. And that is the good side of it. The bad side of it no ma ko e ba ni abakuma shui. You understand? So nyani wo bo amode ni wo kwa jani femo okiyamoko no okiyamoko. Now, a declaration that the purported plotting of the first to fifth defendants' individuals' land in favor of the plaintiff in the records of the Lands Commission was procured by means of fraud and or based on false pretense. Once again, I can plot in any affair ke wo alphabet agba mi because ame sempe me ame indenture sempe stool ame indenture ni ame mamo eni bi ye no ke alphabet ete ne ai title to na kan land there na kan no ame chole ame head na kan no ye gbefon. And order setting aside a supposed land certificate number 38589 dated 18th May 2012 as same was procured by fraud. Kodi kote na kan land certificate ni alphabet na ame kwa chafon ame ka kwekula ame ke hia woni eja ke alphabet achon gbepapa no ni ame ke na kan no. An order directed at the Lands Commission to expunge from its records the said supposed land certificate number GA38589 in favor of the plaintiff and or anything incidental thereto. Ake court take ame yue na kan wa gbene we ame fa ni lands commission na kan title certificate na kan alphabet ame gie yami eja kan na kan no alphabet e ha ame e ka ame chon anokwale gbe no no e woni lands commission ha ame na kan title so ke court hey wo mi ake no na ame yue na kan ye ba ame fa lands commission Bonia face certificate ni your records ni ame perpetual injunction restraining the plaintiff, its agents, servants, workmen, assigns, and howsoever from interfering with the first to fifth defendants' enjoyment and possession of their respective lands. Ni court wafa ake alphabet eke bagba me na don cost of course ke any other thing ni court basmo. Now joinder of 6 and 7 defendant. Ni cases ne te me concro me we Germany na kan no we the same sanya ya me no na ma me file ni ame ba join ni ame fit asande ni ake alphabet aye. It is noted for the record that the writ of summons and the statement of claim were subsequently amended pursuant to the plaintiff adding 2 more persons, namely Carolina Abebrese and Prophet Godwin. So the alphabet klana me blame nyonka bafita nuchuga. So they're sealed as a 6th and 7th defendant respectfully. See pages 18 to 13, volume 1 of the records of appeal. Whilst 7th defendant, Prophet Godwin Nuchuga, entered appearance through a lawyer, Judge Babanawo, the 6th defendant, Carolina Bebrese, could not be traced for personal service. In the result, the plaintiff obtained an order for service of the writ of summons and a statement by substituted service. Although there is the lack of evidence that the 6th defendant did not enter appearance, lawyer Ajenim Boatin is on record to have filed on 7th December 2015 a statement of defense on behalf of the 6th defendant, Carolina Abebrese. In the said statement of defense, the 6th defendant counterclaimed against the plaintiff as follows. So 6th defendant la wonshishi jemia bi amena taule anale alphabet na me ba sue ame so ame apply court for a substituted service. She said me lawyer ni a represent Prophet Nuchuga le no eba ne ba represent man Carolina Carolina la no eba a statement of defense ni a file in a declaration that the 6th defendant is the lawful owner in possession of all that piece of land situate lying and being at Dansoman covering an approximate area of 0.08 acre or 0.03 hectare and bounded on the east side by a proposed road measuring 34.7 feet more or less, and on the northwest by Sempe stool land measuring 100.8 feet more or less, on the southeast by Sempe stool land measuring 100.7 feet more or less, on the southwest by Sempe stool land measuring 38.8 feet more or less, which piece of land or parcel of land is delineated on the plan attached to the 6th defendant's deeds of indenture. Once again, it can indenture chon, it chon any poten de shipon yo. Once again, indenture fa boshiponche. It is the title of the land. I'm gonna keep repeating anytime ni mana no kuwejeme. Take indenture how let us go beyond the indenture. Ni wokwe. Who is the land titled to? You understand what I'm saying? A declaration that the purported plotting of the 6th defendant's land in favor of the plaintiff in the records of land commission was procured by means of fraud and or based on false pretense. So you had the same thing. The 1st to the 5th defendant say an order setting aside a supposed land certificate number GA38589 dated 8th May 2012 as same was procured by fraud and or based on false representation. An order directed at the Lands Commission to expunge from its records the said supposed land certificate number is right there in favor of the plaintiff and or anything incidental thereto. E. A perpetual injunction restraining the plaintiff, its agents, servants, workmen, etc., assigns, and howsoever from interfering with the 6th from the enjoyment and possession of her land. Of course, they're asking for cost and any orders this honorable court may deem fit. Now, there was another people that filed to join the case. Joinder of 8th to 10th defendants. So it did not start. Remarkably, Upon an application for joinder made to the trial court on 20th March 2015 by the lawyer for the defendants, which applications appear on pages 33 to 36, volume 1 of the records of appeal, the following persons were joined to the suit as defendants. So agbene sempe onukpa e kome umba fitai because amame shikoni ni amame hon ha me ne fe ovane like moshwami ni oja ni femon. Now, number 1, ni Adotei Kolebu, head of Pako Berimawe, ni Ashale Asuku, ni Mpa, Impa Komepe, Impa Fane Mi Bodo Manye, Fane Boyo Juba, head of the Tetekeshiwe, and ni Ayidoku III, head of Saka Churu Way, all of Sempe Division of the Gun State, Accra. Pursuant to the order of the joinder, ni Adotei Kolebu, ni Ashale Asuku, and ni Ayidoku III were listed in the suit as the 8th, 9th, and 10th defendants, respectively. That triggered the amendment to the writ of summons and the statement of claim. See pages 129 to 132, volume 1 of the records of appeal. However, the substance of the plaintiff's claim as endorsed on the writ remained unaltered. To contest the claim, the 8th to 10th defendants entered a common appearance that appears on pages 137 to 139, volume 1 of the records of appeal. Following that, they filed a joint statement of defense. See pages 162 to 165, volume 1 of the records of appeal. The 8th to 10th defendants then counterclaimed against the plaintiff as listed here under. So, I'm a counterclaim to noni alpha beta ue no jino of a declaration that the disputed land described in the plaintiff's relief, 1, forms part of a large tract of land belonging to the Sempe stool. Okay, noni alpha beta ba yue ake neke shikpone ni ame title to it. Nagano Sempe ma shikponi. Mind you, alpha beta Gbawe biye on shikpon in a real estate agent ko. Ni real estate agent osamampa ni ame ho ke alpha beta. So in essence, Gbawe biye amekama ame shikponi. Bona. So Sempe onukpa Sempe majancheme ni bafita ya amenkake dabi. Shikponi alpha beta claim nakano Sempe ma shikponi. Ifita shikpon baba jeme ni Sempe ma no. A declaration that a supposed land certificate number GA 38589 of 8 May procured by means of fraud and based on false representation. To Mobeni, the other defendant saying, "You are mommy, you know." An order setting aside the supposed land certificate number GA 38589 of 8 May 2012 as saying was procured by fraud. An order directed at the Lands Commission to expunge from its records the said supposed land certificate number GA 38589 in favor of the plaintiff and or anything incidental thereto. Perpetual injunction restraining the plaintiff, its agents, servants, workmen, assigns, and howsoever from interfering with the 8th term defendants' grantees, including the defendants herein, from enjoyment and possession of their respective lands, cost, and of course, any other orders this honorable court may deem fit. Niamekaba plaintiff filed a response, of course, to enemy. The plaintiff filed a reply to the said defendant's statement of defense and a defense to the counterclaim. See pages 192 to 194, volume 4 of the records of appeal. The 7th defendant filed his defense that appears on pages 190 to 191, volume 4. Once again, also appearing on pages 195 to 196, volume 4, on the records of appeal. Is a reply the plaintiff filed in response to the 7th defendant's statement of defense. Additionally, the plaintiff filed a reply to the 8th to 10th defendant's statement of defense and a defense to counterclaim. See pages 169 to 171, volume 1 of the records of appeal. So, ni meneme fair ba. Once again, fair suit test on the way you are. So far, fair suit plaintiff le way ba file counterclaims to ni BFA ni 10 defendants fair file. Now, the second suit me. So J Kome me mean ke ba ke aboa fen na so a chombo separate suit se fen na because ball shipon I on 2 plot ko am go bi I on 1 plot ko am go bi I on 3 plot ko am go bi I on 4 ko am go bi so p so na get defendant say kaji oje simple no pa me ye first suit tell me I'm a 7. Now let's go to the second one. Seal number LD/0794/2016 Alpha Beta Education Center Limited versus Mama Merly and others. It is worth noticing that the plaintiff filed yet another suit on 13th May 2016, numbered LD/0794/2016 against the defendants listed herein. 1. Reverend Mama Merly. 2. Pastor James Kofi Abri. 3. Mr. Kwame Agbovi. 4. Mr. Penton. 5. Mr. Wuda. 6. Mr. Kwesi Awudugu. 7. Mr. Isifu Mumuni. And 8. Royal Systems and Services Limited. So that's another suit. I mean, 12.9 acres. That's quite huge. Let's go on. A declaration of title to all the piece or parcel of land in extent 5.20 acres, into parentheses, 12.85 acres, more or less, being parcel number 4, block 15, section 059, situate at South Odoko Estate in the Greater Accra region of the Republic of Ghana, aforesaid as delineated on the registry map number 004/059/1991 in the Land Title Registry, Victoria Berg, Accra. Recovery of possession, damages for trespass, perpetual injunction to restrain the defendants and their assigns and privies and workmen from trespassing on the plaintiff's land. Number 5, cost. Filed the same day as the writ of summons was a statement of claim that appears on pages 206 to 209, volume 1 of the Records of Appeal. Appearing on pages 222 to 223, volume 1, Records of Appeal is a notice of appearance entered on behalf of the 8th defendant. The 8th defendant then filed a statement of defense and counterclaim against the plaintiff as enumerated here below. So number 8, ni yo no, le filed a defense. No they can. A declaration that the 8th defendant is the lawful owner in possession of all that piece of parcel of land situate, lying, and being at Dansoman in the Greater Accra region, commencing from Survey Pillar SGGA EX06/1 on a bearing 253 degrees 061 at the point of commencement marked 2. Thence, from the point marked 2 to the point marked 3 on a bearing of 216 degrees 471 over a distance of 99.53 feet. Thence, from the point marked 3 to a point marked 4 on a bearing of 306 degrees 341 over a distance of 140.48 feet. Thence, from a point marked 4 to the point marked 1 on a bearing of 036 degrees 551 over a distance of 97.24 feet. Thence, from the point marked 1 to the point of commencement marked 2 on the bearing of 125 degrees 381 over a distance of 140.28 feet, containing an approximate total area of 0.32 acre more or less, which said piece of parcel of land is delineated on the plan attached to the 8th deed of indenture. Once again, the indenture is not enough. The indenture is not enough. Me yueko anytime ni manager me ma yueko min panye fai wa meni wa yo man say nya ni wa ke kase ani. Indenture, it is not enough. Nya ni wa kwa wa fear set ni wa kwa ke who owns the title to the land. The indenture is not enough. The indenture is not enough. And we keep making these mistakes every single time. You understand what I'm saying? That is why I love doing this, because that is why I love it when you because I have one tibli ni yomi. You understand? Because what I mean, what name ona no ji in danger. Meaning tabie agagwe yemi dan. Ayabache agagwe yele dan. Okaleche agagwe yele dan. Wa eten no na ninche wa fe kwa wan share wa personal experiences can boy obana ga wa eten fe agagwe ye wodan. You understand what I'm saying? Agagwe ye wodan. So me panify wa many your man say always come go ba ho no kwa wo kwa title nke me akekwe ye mi ayabache akekwe yele okaleche akekwe yele. You understand what I'm saying? Let us go beyond the indenture. Let us go beyond the indenture. Let us go beyond the indenture. That alone will not cut it. You know, I ended up paying for the same land twice. The same land. In Pele Shienyo. You understand? Because kawana indenture no be wanjo fui. If you lucky ake in pay shpon keke ko imagine na can be anyon no go mano. Eke mo ke dabi you understand what I'm saying? Beni anamoni lenche won shpon no mi mokoe wo shikomo agbene mo le won isani wo pele because shpon le no so mi panify call your man say go beyond the indenture le you understand mi pabo fai wa de enche mi pabo fai ene me fe be wo ken kaseni be no onu e be wo ken kaseni ageko nani moko chensha ege bo mini oba yenu amo no yi e go fe ready. You understand what I'm saying? So jani fe mu kiamoko no kiamoko ya yishiba mi dabi atoka nkpanye ke nkake kehamoko ni leun e kehamoko so kehamoko ni leun e kehamoko na kanjibo ni impact in really. Let's go on. A declaration that the purported plotting of the 8 defendants' land in favor of the plaintiff in the records of the Lands Commission was procured by means of fraud and or based on false representation. Let's go on. An order setting aside the supposed land certificate number GA38589 dated 8th May 2012 as same was procured by fraud and or based on false representation. An order directed at the Lands Commission to expunge from its records the set, into parentheses, the supposed land certificate number GA38589 in favor of the plaintiff and or anything incidental thereto. 5. Perpetual injunction restraining the plaintiff, its agents, servants, workmen, assigns, and howsoever from interfering with the 8th defendant's enjoyment and possession of its land, cost, and of course, any orders this honorable court may deem fit. It has appeared that the personal service of the writ and statement of claim could not be effected on the first 7 defendants. In the result, the plaintiff successfully applied for an order of substituted service. Following that, the plaintiff filed a motion for interlocutory judgment in default of defense against the first 7 defendants. See pages 238 to 241, volume 1 of the records of appeal. Joinder of 9th and 11th defendants. Once again, Cheme ni ame represent or Sempe Shian Wuljin eten ame kame ya womi because ame here ame yake na kan shupon Judgement Gbawe biano Sempe biano. Joinder of 9th and 11th defendants. It is worth noticing that on 21st April 2017, a motion of notice for joinder was filed in the lower court, which the lower court granted on 3rd May 2017. See page 200, volume 2 of the records of appeal. Pursuant to the grant of the joinder, Ni Adote Kolebu II, Ni Ashali Asuku, and Ni Ayi Dogu III were joined to the second suit as the 9th, 10th, and 11th defendants, respectively. By reason of the joinder, the plaintiff amended the writ and the statement of claim accordingly. Upon being served with the amended writ, the 9th to 11th defendants entered a joint appearance that can be found on pages 214 to 215, volume 2 of the records of appeal. The 9th and 11th defendants filed a joint statement of defense and counterclaimed against the plaintiff as follows. A declaration that the disputed land described in the plaintiff's relief as I forms part of a large tract of land belonging to the Sempe stool. Once again, Akanakajame Sempe Mano. A declaration that a supposed land certificate number GA38589 of 8th May procured by means of fraud and or based on false representation. An order setting aside a supposed land certificate number GA38589 dated 8th May 2012 as same was procured by fraud. An order directed at the Lands Commission to expunge from its records the set into parentheses, the supposed land certificate number GA38589 in favor of the plaintiff and or anything incidental thereto. Perpetual injunction restraining the plaintiff, its agents, servants, workmen, assigns, and howsoever from interfering with the 9 to 11 defendants' grantees, including the defendants herein, from enjoyment and possession of their respective lands. C. Cost. Number 7. Any other orders this honorable court may deem fit. Issue for trial. Agbene abajeshishin. Judge Semba ni ameba chonwo. Shout out to you, Felix Aikwe. Ameba namba chonwo. Ni bi na akegmi amehiye. Manage no ni sanieba ni ameba ye. Shout out to you, Brakote. Mr. Ray. Mo kulabe ofanebe bo yojuba. So man Venus bo yojuba. So agbene judge Semba namba kewo. Sanie akabagma amehiye. Mini ameba kwe ni ameye. So issues for trial. Let's go. Jani Femo Amigonti Kiamoko ni Okeyamoko Mene Saturday Nkega we wo chele. After close of pleadings. No. Ogbena for the day. Onu Obanyo ka wo charger she okodon. Okay? After close of pleadings, 2 applications for directions were put before the trial court. The issues set out in both applications were the same. It shall be superfluous to repeat both in this judgment. So, ni agbe pleading say na meneba yene na ba kwe. Ame fa me na ke sanjin fe ekomeni. So, it shall be superfluous. In other words, it will be unnecessary. It's like I repeat the same thing because sani fe ekomeni. So it will be unnecessary to actually now I feel separate. But in this regard, I prefer to set out as follows. Issues contained in one of the applications agreed upon, namely, so both counsels agree, whether or not the disputed land originally belonged to the Gbawe stool. So in aba energy no ni abakwe abaye na kwake ani leleng sane because like I said, on got 2 separate suits. She fe sane fe komeni. So judge it will be useless. Ni wabake when you suit number 1 work be na dan wabata to me. That's what superfluous means. It means unnecessary. You are giving too much information. So about feel komi. You understand? Now, so abaye can clean on abakwe and in a can shipon lelake Gbawe bia no lo because mind you in Kebake Gbawe ameoa Osamampa estate real estate company ni real estate company on Alpha Beta. So sane kenkle ni sane ne abakwa yemi na yejake and lelake na can shipon Gbawe bia no lo. Number 2, whether or not the land in dispute was affected by the judgments in the case of Yadoade Crab versus J.A. Kwe, suit numbers 22/1948, 5066 and 8990. Now, Yadoade Crab case in Canada, I've made reference to it several times. But in this case, no, you know, is one of the cases ni Sempe me domono ni amekake na kenjeme shipon fe amame no nie. So abakwe whether Gbawe bia no alo abakwe ake neke case ne na yene ani neke case ne ani ni efe fan ake na kenjeme shipon Sempe ma no lo. See whether or not a defendant's grantor could have validly granted the land in dispute to the 8th defendant. D, whether or not the land in dispute was acquired by fraud by the plaintiff. Onake fenko defendant seni Alpha Beta kamete free. Ame kwake Alpha Beta acquire a title to the land through fraudulent means. Whether or not defendants are trespassers on plaintiff's lands. Agbenewe Alpha Beta ka ame bi nibi from court. Ame bi oni court I declare ke me ni me yo na kan shipon no. Ame trespass. So that's another thing. Ni akwe. Whether or not the plaintiff is entitled to its claim. And in nibi any Alpha Beta ke ba fen. E jino ko ni esani ake ha melo. G. Whether or not defendants are entitled to their counterclaim. Agbenewe bakwe. Keji esani akeha Alpha Beta and the defendant say many men are home the keshipon jine fen ha many Alpha Beta and town jam no and the mama sane yamin lo ni sana shiame ni shipon ameko ame shipon lo. Any other issues arising from pleadings. Let's go on. It bears emphasis that by an order of the lower court made 27 March 2013, both cases in the present appeal were consolidated for trial. So, even at the lower court, cases say no you understand? So this is more reason you want to agree with the judge. Okay, it will be superfluous. You deal with one, then you deal with another one. It was obvious, given the pleadings the parties filed, that the same facts and law run through the consolidated cases. To get defense, the same thing. I'm indenture from the Sempe stool, title any alphabet I can title it through fraudulent means. Alphabet only be na you and I can know they own it. I'm a fan again. I can harm a title to the land and all of that. So you can understand why I need trial judge make it. Now the law on consolidation. So judge a chonwa mini jimla ni a cover keji sanji swati ni atao ni afele ekomie mini jim mla ni a cover nakaino. So let's go on. The purpose for consolidation of cases is to save cost and time. The law first stated in Payne versus British time. I don't know if we have to go through all these authorities any as cited. You understand what I'm saying? Okay. I'm going to just read them without explaining anything in Ghana. Bona, just go ni one anywhere fast. The law first stated in Payne versus British Time Recorder, CO. Hey, 1921 to KB1 at 16 establishes the principle that consolidation will normally not be granted unless there is some common question of law or facts being sufficient importance in proportion to the rest of the subject matter of the actions to render it desirable that the whole should be disposed of at the same time. That this well-established principle of law has been followed and applied in a legion of cases cannot be overemphasized. Indices of consolidation. I set out here below as guidance for practitioners and trial courts. The indices of consolidation of cases this court outlined in Agboado versus Fianco, 1995 to 1996, number 1 Ghana Law Review 278 at 281. That is to say, consolidation is to enable the hearing to be facilitated and expedited. That no I waste time. That a separate judgment has to be delivered in each suit. The individual identity of each of the consolidated suit has to be maintained throughout the proceedings up to execution. Pleadings filed subsequent to consolidation has to clearly specify in which of the consolidated suit if was being filed. Having ordered the consolidation of those cases on the authorities, it was incumbent on the learned trial judge to have shown by his judgment that he was delivering either 2 separate judgments or a single judgment. If the learned trial judge was minded to give 1 single judgment, it was duty bound in law to offer reasons for arriving at the same or different conclusions in respect of the 2 suits to reflect the distinct nature of each case. The Court of Appeal, speaking through Benin Justice of the Appellate Court as he then was, stated that the law in Yao Atuahini and Ano versus Botantim and Ano JBA. JBA. Where a single judgment has to be delivered in the absence of separate judgments, there was a duty on the trial judge to give reasons for arriving at the same or different conclusions in respect of the 2 suits to reflect the distinct characters of each case. That is lacking in our present case. The learned trial judge never took pains to give separate judgments, or if he intended to give 1 judgment, to state so specifically, contrary to established principles stated before. All that the learned trial judge did was to conclude his judgment as follows. having examined the oral and documentary evidence adduced by the parties on the balance of probabilities, I hereby grant only relief A of the reliefs claimed by the plaintiff, since that was what they were able to prove, and dismiss the other reliefs. In respect of the counterclaims of the 9th to 11th defendants, I hereby dismiss all their reliefs claimed, save relief E, since their processory rights has already been confirmed by the Supreme Court. In respect of relief G, I hereby affirm the exclusive processory rights of the Sempe stool as granted by the Supreme Court in Niyaw Duade versus J. Ekwe in 1990, no order to cost. So, Judge a tron reason say woni boli ni bi ekomeni onage kokwe judges a split baby. So, e han plenty fair ko ni e han defendant say ko. So, e ka yes, sempe me lele aka na kan shipon amame noni at the same time en we ke yes plenty fair title shipon noni e na title you know e ko. So the judges split baby and of course no one anybody appeals court. It is obvious that the conclusion of the lower court runs in conflict with well settled incidents of consolidation. So judge en chono kwake boni ebale je na kani keji ochasanjin enyo ni oye it's an fail fan keji o fe o rule one side yes and the komeno ni o rule another side yes and the komeno it's an no fe no afe fan no ne woni this side there o rule neke and no any another case enwe o rule neke because o chasanjin enyo no ye so chomo is an no chon no any fe fan no ni sane e o te neke direction ke sane b enwe o te na kind direction. The learned trial judge never gave two separate judgments, but one. However, in a single judgment, the learned trial judge did fail to consider the separate and distinct nature of each case. So long as the trial court never applied the proper test, the interference of the Court of Appeal with that aspect of the judgment is justified. So no appellate court is may apply the proper test of consolidation because Bonnie J feel Nakani. Going forward, I shall consider both cases in this single judgment, but in separate and distinct nature of each one in conformity with the settled principle. So once again, Bonnie ni J Nakani ibakwe ni ebote mli ojogba dienche. Let's go on. The appeal. The law is certain that an appeal is by way of rehearing the case. So anytime, no, you understand? The Court of Appeals Rule CI 19 per Rule 8.1 provides that any appeal to the court shall be by way of rehearing. This rule has received ample judicial interpretation in a legion of cases to mean that the appellate court is enjoined by law to review the whole evidence let on record and to come to its own conclusion and to make a determination as to whether both on the facts and the law, the findings of the lower court were properly made and were supportable. Put differently, the appellate court is under legal obligation to examine the findings of the lower court or the trial court and to determine on the evidence let on record whether those findings are supportable in law. On the authorities, where a trial court that heard the evidence has made findings based on the evidence and come to the conclusion in a case, an appellate court is not required ordinarily to disturb those findings, except where there is lack of evidence to support the findings or the reasons for the findings are unsatisfactory. As per man, Justice of the Supreme Court, Justice stated in Professor Stephen Adey and Mrs. Georgina Adey versus Grace Robertson and Sempe Stool, civil application number J4/2/2015, delivered 10th March 2016, unreported. An appellate court may reverse findings of a lower court where they are based on wrong proposition of law or a rule of evidence, or that the findings were inconsistent with documentary evidence on record. Indeed, It is settled law that where the findings are clearly unsupported by evidence, or where the reasons in support of the findings are unsatisfactory, the appellate court reserves the power to upset those findings to the trial court. See Chiafi versus Wunu, 1967, Ghana Law Review 463 at 466. It is important to stress also that where the findings are based on wrong proposition of law, the judgment of the lower court is liable to be set aside. The case, Robbins versus National Trust Company, 1972, AC 515, illustrates the principle that where the finding is so based on erroneous proposition of law, the appellate court is empowered to correct it, and having corrected it, the impugned findings then disappear. Legal analysis and opinion of this court. I proceed to consider this appeal on that account that both parties have filed their respective notices of appeal as recounted supra before. It was the plaintiff that first filed appeal against the judgment of the learned trial judge, Amu Yate J, which notice of appeal appears on pages 115 to 117, volume 4 of the records of appeal. It is on record that the defendant subsequently, on 10th August 2021, filed before the lower court a motion or notice for an order of extension of time within which to conduct appeal out of time under Rule 91B of CI 19. That rule provides, 1, subject to any other enactment governing appeals, an appeal shall not be brought after the opinion of B, 3 months. In the case of an appeal against a final decision, unless the court below or the court extends the time. So clearly, defendant say, I may apply for an extension of time. Boni afeni amenyeni ame appeal afemini abba Ghana lenche abega mini bi atuni case say gumeni wona may file appeal within the stipulated time when again le unga me ba won Ghana. Upon the lower court granting the application, the defendants filed their notice of appeal pursuant to the leave granted. The said notice of appeal appears on pages 128 to 126 of C of volume 4 of the records of appeal. Traditionally, where a party in whose favor a judgment invariably went, but was regardless dissatisfied with the portion of the judgment, shall give a notice of variation in accordance with Rule 15.1 of the Court of Appeal Rules CI 19. That provision of the rules provides, 1, it shall not be necessary for the respondent to give notice by way of cross appeal, but if a respondent intends upon the hearing of the appeal to contend that the decision of the court below should be varied, he shall within 1 month of the service upon him of the notice of appeal cause written notice in Form 7 in Part 1 of the schedule of his intention to be given to every party who may be affected by the contention. The rules vest in the Court of Appeal jurisdiction to vary only the impugned part of the judgment complained of Rule 15.1 of CI 19. Does not require the respondent to also file a separate notice of appeal like the appellant. Put differently, the respondent finding himself in that situation shall not file a cross appeal, but shall give a written notice of variation of part of the judgment complained of. The proposition that a respondent to an appeal should not file a cross appeal, but to give notice for variation of judgments, finds support of the Supreme Court in the case of Dodu versus Adumanku 2012, number 1, Supreme Court Ghana Law Review 198, where when the Apex Court held. The rationale behind Rule 15.1 of CI 19 was that it was in the nature of cross appeal and for practical purposes served as an alternative to a cross appeal. Under the rule, a respondent to an appeal finding himself or herself not fully satisfied with the decision of the trial court, albeit a favorable decision, would rather file a cross appeal exercise the option, exercise the option of requesting for a variation of the decision complained of. The application for variation was thus employed to correct not assigned reasons, but the decisions of the trial court. Notice of variations were therefore not intended to be deployed to procure from the appellate court exhaustive reasons to reinforce a reasoned decision, which in all aspects was sound and correct. Emphasis mine. So judge and chono wake no ne blame ye BFN le a understanding of the law as it is nakajinoni ike will be. It is instructive in our present appeal that the grounds of appeal contained in the notice of appeal filed pursuant to leave of the court clearly show that the defendants intended to appeal against the whole judgment of the lower court and not to give notice of variation of parts of the judgment. The learned authors of Atkins Court Forms 2, Forms 2nd, ED Volume 5, Lord Evershed, P. 63, paragraph 74, I've stated the general rule that where parties serve separate notices of appeal without reference to each other, each will be a substantive notice of appeal entered separately, but appeals will be listed for hearing at the same time. So, no what can you offend? Clearly, anyone now the judge, the appellate court, make my decision. It took an exception to the way the lower court judge it went about ruling on the particular case. You understand what I'm saying? So no generally explain off that is why I install PD ma try to be a comment. Let's go on. Now, adding to the fact that the notice of appeal the defendant filed pursuant to leave of the lower court did not make reference to the appeal plaintiff had filed earlier, the notice of appeal of the defendant is a separate and distinct from the plaintiffs, and both appeals have to be considered on merit. I now return to the grounds of appeal the parties filed. So I'm about to take grounds of appeal. And let's go. I intend combining the plaintiff's fourth ground of appeal and the defendant's second, third, and fifth grounds of appeal and address them simultaneously, since all those grounds speak to the same issue, i.e., the finding of fact that the plaintiff, though entitled to a declaration of title, the lower court still refused the lower court still refused to grant it recovery of possession. Those grounds of appeal are reproduced here below as a matter of emphasis. So nyebaka yake lower court et mobeni nke eke the title any alphabet anye to the land there ambanya menye. It is okay. At the same time kake sempe mashipon ama menoni. Meanwhile the defendant saying kake dabi kaji okay shipon you wa noni ni get title any enough from the lands registry but enale through fraudulent means, because one many o kake wa shipon you na kan shipon je wa hale. You understand what I'm saying? So clearly, like in judgment, you can tell from the very get-go, it makes sense. Moko oko shikwe hamuko. Moko ena title, you know. Okay, mo ake ba keep a title. At the same time, you wake o many shipon ameka ama menoni ama menoni. You see that conflict? All right. Plenty for ground of appeal. The trial judge erred in holding that the Yaoduade case in which judgment was given in 1963 granted possession of Akukor Foto lands to the Sempe stool. So once again, alphabet and kakedabi, Yaoduade case any Sempe me dumono. Ni amekwake Supreme Court yuake Akukor Foto shipo ama menoni alphabet and kake nakaino J nakaini. Now, number 2, defendants second, third, and fifth grounds of appeal. So defendants say number 2, 3, and 5. Me you know na make second ground. I'm a second ground of appeal. Dabi defendant say I'm a second, third, and fifth grounds of appeal. I'm a number say in terms of number. I'm a second ground of appeal. The learned trial judge erred when he held that Akolache J's judgment of 1963 covered the disputed land and yet stated that the plaintiff was entitled to a declaration of title to the disputed land. So no judge and quite the same thing. I'm a third ground there, Jimmy. The learned trial judge erred in that affirming Akolache J's judgment of 1963 in the Yaoduade case, which granted possession of Akukor Foto lands to the Sempe stool, proceeded to decree title in favor of the land. So the same thing. You cannot say Ake Sempe Mashiponi and then all the same Ghana judges. My goodness. Once again, I'm not a lawyer. I don't play one on TV. I don't intend to play one on TV. This is from just a layman's point of view. You can decide lawyer fifth ground. The learned trial judge erred After holding that he does not have the slightest part to deviate from the decision of the Supreme Court per the hierarchy of the court, as is bound to follow the decision of the Supreme Court, failed to depart from Ofoe's judgment of 2006, which had declared title in the disputed land in favor of the plaintiff grantor's predecessor. So once again, judge in Chono Kwake, Keji lower court judge agree ake Supreme Court decide go final. Te fiote ni at the same time court judgment in the Supreme Court they decide okay shikon sempe mano. No te fiote ne yo judgment from a lower court judge foi ni ko ake me title na amena buashiyame even though he declare ake shikon je amame me ni me ho ya le je amame no ni. If I yeah, be 1 minute. We shall be right back.
I see the sunlight, the smiling in my window. Feels like holiday. It's a holiday. I hear the sound of the birds as they're singing. Hello, Africa. Let's celebrate, yeah, let's celebrate. We dance in the morning, in the evening. Amazing people from Africa, yeah. We dance in the morning, in the evening. Amazing people from Africa. Everybody, let's go. We go party, party with the rhythm of the party with the rhythm of the music. Party with the rhythm and the music, yeah. We go party. Party with the rhythm with the music. Charlie, make we party. Party with the rhythm with the music. Kule, what's your number? Boys and girls, Charlie, what's your number? Kule, what's your number? Boys and girls, Charlie, what's your number? Oh, it's time to party. Oh, lots of fun in Africa. Oh, it's time to party. Oh, lots of fun in Africa.
Right, now we're channel. I shall then consider the plaintiff's first ground of appeal with the defendant's fourth ground of appeal and address them together. Plaintiff's first ground. The trial judge, after affirming that the plaintiff was entitled to a declaration of title to the disputed land, erred in not granting the relief of possession. So then we the same thing. If flip it around, you cannot say okay, I'm entitled like a title like a title in yet to the land legit ning pakani enya shimo obake shipon jemi no is an akia sempe me. So let me flip the other side of the coin. Then we argued pretty much the same thing. Defendant's fourth ground. The learned trial judge erred by holding that the plaintiff was entitled to a declaration of title to the disputed land. So the same thing I take back and forth. Now, let's go. I shall finally discuss the omnibus ground that the judgment of the lower court is against the weight of evidence. So, Noji, bam, the main one. Both parties in their respective notices of appeal have contended that the judgment of the lower court is against the weight of evidence. I proceed to discuss these grounds of appeal against the backdrop of the crucial issues the parties agreed upon for determination by the lower court in the two consolidated suits. Resolution of the first suit, suit number FAL/558/2014, Alpha Beta Education Center Limited versus Nana Osei Bonsu and others. In this case, the plaintiff claims title to the land. The subject matter of the dispute are described in the writ of summons, with the dimension of the land fully provided for in paragraph 7 of the statement of claim. It is trite knowledge that in all civil cases, a party wins on preponderance of probabilities. Thus, the plaintiff herein carries the burden of proof to the satisfaction of the court that its story was more probable than its adversaries. Otherwise, it fails in terms of SS 12 and 14 of the Evidence Act 1975, NRC D 323. Bona. So in civil cases to Monike, in criminal cases, the burden is on the prosecution to prove beyond a reasonable doubt crime has really been committed by this person. You understand? So in criminal cases, the burden is on the prosecution to prove a crime has been committed beyond reasonable doubt. In civil cases, it is based on the preponderance of I'm a quote and of course it's self-explanatory. It is based on the preponderance of probabilities. Bona. In this case, the burden once again the plaintiff carry the burden of proof. Ni isani of course story any kaji akwe all the probabilities say akwe lele enyon a favor. Bona. So are you probability, not absolute. You understand what I'm saying? Whereas in a criminal case, it must be beyond a reasonable doubt. You understand? There must be no doubt whatsoever. You understand? In civil cases, not so much. It's just on the preponderance of probabilities. So in this situation, okay, so let's go on. It is material to point out, however, that defendants not only accuse the plaintiff of fraudulently obtaining a land title certificate to the disputed land, they additionally claimed title to the land. On the authorities, a party who counterclaims also carries the burden of proof. So because I'm a counterclaim, so this time around J plaintiff Monica Sani ba pe ni esani agbene leun prove ni chwake okay esani ede ke ba no ne shak bene because defense and we counter claim they are not just defending no ni plaintiff ke ba me burden eko ya me no na am asana me prove ake am esani na me ke ba. It is correct. Indeed, one of the key questions that tends for consideration and resolution in the case is whether paid Akolache J's judgment. Now, pay attention. You hear the Akolache judgment all the time. You hear the Akolache, na Akolache, na Akolache, na Akolache, na Akolache, na Akolache. Now, what boatwe? No ni appellate court you yeneka Akolache sandine. Indeed, one of the key questions that tends for consideration and resolution in the case is whether paid Akolache J's judgment title to the disputed land was decreed in the Sempe stool, or the stool giving processory rights that was confirmed by the Supreme Court. So, any Sunday, well, Sempe stool, ni ame kwake shikwa ama ame no niye, ani ni ame saito Akolache judgment ani anukwali ake Akolache judgment miye, efele fang ake Akukor Foto shikpon sempe ma no lo ni engono ake na kano isani ake a sempe me lo. You understand what I'm saying? No juno na ba akwe so bono ni aba you e because so no ni sempe me ame for Akolache judgment site mo. Now, for purpose of clarity, I set out in verbatim the assertion by the 8th to 10th defendants pleaded in paragraphs 8 to 10 of the statement of defense. So, a Koti defendant say, noni amewe a paragraphs 8 to 10 of their statement of defense. A Koti ame in further reaction to the said paragraphs 3 to 7, referring to plaintiff's statement of claim, the 8th to 10th defendant shall say that the land described in the said paragraph 7 forms part of a large tract of land belonging to the Sempe stool, a portion of which was granted to the 1st to 5th defendants. So, again, quote, okay, no defense ba domono na me wi ake lele ne ke shipon ne ni ahon the 1st to the 7th defendant say sempe ma anoni. It is part of shipon agbo ni sempe me ono jame fe na me floeko ni ame hon ke the 1st to the 5th defendant. Number 9, the 8th to 10 defendants shall further say that the disputed land has been declared to be part of the Sempe stool lands by Akolache J, as it then was in the case of Yaduade Crab versus J.A. Kwe, seal number 22/1948 judgment of the High Court, dated 10th May 63. Once again, defendants 8 to 10 Sempe Majiacheme ni ameyo bole Pako Berimawe Sakachuruwe ke ameyete those 3 big houses Sempe Shian Wujin ni Sempe Majiacheme ni yon amameji defendants 8 to number 10, 8, 9, and 10. Ameni. So I'm about you ake neke ya do crab case in Justice Akolache case enwe neke enyone fele fan ake na kenjame fe Sempe ma shiponi na kanjino ni ameba you. Number 10, the 8 to 10 defendants again say that the said judgment of Akolache J, as he then was subsequently affirmed on appeal by both the Court of Appeal in suit number 50, 66, and the Supreme Court 1989 to 1990, number 2, Judicial Law Review 393 to 407, 31st July 1990, which said the courts apportioned lands to the west of Accra, including the disputed land among the Sempe, Jamestown, Alata, and Akomaji stools. See pages 163 to 164, volume 1 of the records on appeal. So, once again, onukba majancheme ni Sempe ni amameji defendants and again no me 8, 9, and 10 ake Akolache judgment na kete appeal na kete Supreme Court amemanomi ake lele na kanjame be Sempe mano ke Jamestown ke Alata aja na kanshiko die ni yo je ihame na kanjuno ni Sempe majancheme amebayu. Undoubtedly, this assertion is the anchor sheet upon which the 8th, 9th, and 10th defendants heavily rely to claim ownership of the land, the subject matter of this suit in their counterclaim. So, Jaja Ntano Wake, ke okwe neke cases ne, ya Duade Akolache, neke cases ne, no juno ni Sempe Majancheme, ni amioneke na amen dumono 3D ake, neke cases ne, ni chon ake lele, na kanjame be, shikon, amame, noni. You understand what I'm saying? Kiamoko no kiamoko, Jani Fimo. Let's go. In its reply, that appears on pages 169 to 171, volume 1, on the records of appeal, of an amigonti. No, ya ngweko onu. Koba fita we no like iko show e bomodi. The plaintiff aside denying the averments contained in paragraphs 8 to 10 of the 8 to 10 defendant's defense, and its defense to the counterclaim specifically averred that the disputed land in the present suit was never affected by the Akolache J's judgment. So plaintiff and Chono Kwake, in this case, Alphabet and Chono Kwake Dabi, Keji Ameke Akolache judgment ni efele fang ake na kan shikpo ama me no nie na kan no je anu kwale ni eja ake shikpo sane na you Akolache judgment ne ya a cover na kan shikpo na you sane hi. This is what the plaintiff is saying. Ake Akolache judgment a cover no noni Sempe Majiacheme na men dumo Sempe na jian ni amen yue na kan no ameke no pagbi. As regards whether the disputed land in this appeal was affected by Akolache J's judgment, the lower court in its judgment, as appearing on pages 98 to 99, volume 4 of the records of appeal, held as follows. So, noni lower court on the issue of whether or not the land in dispute was affected by the judgment in the case of Niya Duadekra versus J.A. Kwe, seal number 22/1948, 50, 60, and 1989, 90, counsel submits that the judgment of the High Court in the case of Niya Duadekra could not have affected the land in dispute because the said case of Niya Duadekra was about a piece of land at a place called Mimete in Accra, which is present day called Russia in Accra, which is far from the subject matter of dispute, and that the said case was mentioned in the consolidated case of Ni Adoto Obua II versus ICOM Limited and 4 others, suit number L215/2001, at page 45 of the judgment. This is the learned trial. This is what the learned trial judge said. So, even at the lower court, that's why in no judge, Bonnie, if any, you cannot give possession of the land to one group and give title of the land to somebody. Even lower court any possession of the land to Sempe. Le enone we be akaniake. Naka ya doade case na ye. Naka shiko no na apelio ye bi ane e cover ano. Aywe e kona chole ngmete sani. Akukor Foto sani na yo bi ane ebemi. You understand? So appellate court judge in anyone awole yake dabi even though naka no pone e Sempe ma possession it make it clear ake naka ya doade crap ke kwe no na ye Akukor Foto sani ebemi ngmete sani na ayo. You understand what I'm saying? So enye cover nekeno kone jeje feel clear. Now then we have a 1963 a judgment a court ni ya doade crowd the third versus ni Akukor co-plaintiff ni ya doade crowd plaintiff can ni Akukor the second co-plaintiff versus J.A. Kwe defendant versus ni Tetekpeshi co-defendant bona. Now by Akolache J suit number 22/1948, this was admitted at Exhibit QQ and it featured prominently in the address of both counsel. I read the judgment closely, but did not see the exact impact the judgment should have in the dispute before me. So, Judge Nchono Gwake, neka kolache judgment ne etene akanelo jogba ni enu shishino no ni nakaino any appelio ye esani ekoyeko. The claim of the parties in Yaodoade's case concerned Memete, which has been clearly marked on its judgment plan as Exhibit UU. So, Judge Nchono Gwake, neke akolache judgment ne ni I rely or no. No, are you Akukor Foto sani? She are you Memete sani? Memete sani jino na you. No, enu shishino no ni a kotuno ni akeno supporti neke Akukor Foto sani ne. Let's go on. It is true that the judgment mentioned the Akukor Foto, but all it said was the co-plaintiff has satisfied me that the village Jankobi and its surrounding lands are exclusively under Alatas II by the settlement which was made by the permissions of Alatas II. Emphasis added. So, yes, yes, acha Akukor Foto sani. Chino achena ke fita yake o aklora conclude jame na chole Jankobi kana kanjame gbefe Alatas II bi ano. Oda. So nakajino ni jeje. Ironically, the lower court in our present case had earlier observed that it did not recognize the impact of the judgment of Akolache J on the present case. Once again, I do not understand why the Sempe II continues to rely on the Akolache Sania, even though ahame possession of Akukor Foto lands from none what discuss on ne. She judge ni ye na kan Sania no mi dabi Akolache Sania called me Akukor Foto baby. Once again, over an lay England na kan jame ni bi ojogba. So don't take my word for it. Kake mi ake min kan no na ke. Nle ake Akukor Foto ye me. I don't know. Nle ni me John she ne agbe on aye. I'm not a lawyer. I'm not playing one. I'm just selling this, reading what has been said. Maybe yes, I mentioned me. You understand? Nevertheless, it proceeded subsequently to hold in its judgment as appearing on page 109, volume 4 of the Records of Appeal that the Sempe II once granted the subject land to Agricultural Development Corporation and that the grant was tantamount to possession. Nakano Jinoni Akolache make Nakano clear. It further stated that Akolache J's judgment held that the Sempe II was in possession, and that was affirmed by the Supreme Court. Akolache a judgment really clear. Poetry farm Sempe Jimoni keha. You understand what I'm saying? That judgment of the Supreme Court therein referred to is reported in the Ghana Law Report as Jamestown Alatas II, and ANR versus Sempe II and ANR 1989 to 1990, Second Ghana Law Review 393. As a matter of emphasis, the chief question, which is at the heart of the judgment, that must be answered in our present appeal is whether the Akolache J's judgment, the Sempe stool, was held to be honest in possession of the land. So Jajan Kake, so noni kawa here is ani what ni wakwake ani leleng Akolache judgment ni Sempe me dumono ani lelake Akolache judgment efele fang ake shikone na appeal here Sempe ma no lo. The subject matter of the instant dispute and were granted possessory rights, which possessory rights the Supreme Court affirmed as the defendant's claim. So now kwake anilela ke Akolache to many yue ekeshipon sepe manolo ne as a Supreme Court we and the Supreme Court manomi akelele noni Akolache yue ani nakanolo. Now, it has been submitted on behalf of the plaintiff that contrary to the defendant's assertion that the Sempe stool was given possessory rights in respect of the disputed land by Akolache J's judgment, which possessory right the Supreme Court affirmed, Akolache J rather dismissed Sempe stool's claim. So, Jaja Kake, plaintiff, anini efe fan ake, dabi, ke Sempe men kake, Akolache, yue lefan, ni ekamake, shipon, amamenoni, dabi, Akolache mon kake dabi, nakano, shipon, je amamenoni. That is what they are saying. Now, our channel. In his written submissions filed with this court at page 15, learned counsel for the plaintiff was emphatic that Akolache J never granted possession of the Akukor Foto land or any other land to the Sempe stool. So plaintiff alphabeta I'm a lawyer Jimoni you are kadabi. Keji defendant ke Akukor Foto no Akolache fele clear ake Sempe mano dabi nakano ameke pangbe ni je anu kwalini. Learned counsel for the defendants on the other hand in his written submission on the point reiterated that holding of the lower court that the Sempe stool was in possession and that just Akolache J's judgment affected the disputed land was supportable. So once again, the defendant said, "Abi, no, you are jenake. Akolache J fele clear. Justice Akolache fele clear. Ake nakanshipon wawanoni." From the available evidence left on record, it is not difficult to find that the Sempe stool was not entitled to possession and was therefore never granted any possessory rights over the disputed land. So, evidence say ni your record no need na a chon market dabi Akolache J a grantee Akukor Foto ke ha Sempe noko bena kani eka ke name Sempe manoni. In the said ni yaduade crab cases consolidated, the Sempe stool was joined to the suit as co-defendants. So naken sania na yo I'm a Sempe mem where I'm a bafitai as defendants. I'm a fitai. Page 21, volume 2 of the record of appeal. Dismiss the counterclaim or the case of the Sempe stool. So jage naken sania yaduade sania na me you mo Akolache mo counterclaim ni Sempe make ba Akolache what nakan claim any Sempe make by a way chaff. For purpose of clarity, I reproduce here below that portion of the judgment. So, jeke, koni no fe no afe fan wa meni wa kanyo ni wa fe wa buoto ne e ba kane no ni Akolache na can judgment here yue. Now, the counterclaim by co-defendant I hold failed upon the evidence touching upon the whole area in dispute. I therefore dismiss co-defendant's counterclaim. So any judge a quote from Akolache J. No, okay. They were joined as co-defendants. Ni claim na amekeba awofe achafun. Judge quote directly. What I know. It is material to stress that the two critical issues set out and which the parties agreed upon for trial and determination by Akolache Justice in the consolidated suits were 1. Whether the said land comprised in this consolidation action are Jamestown Alata stool lands or Sempe stool lands. So once again, Ataoni Akwake ani Bonia you are one of the things ni is ani Akwananaji ani Akolache ehani ayuake na kenjeme Jamestown alata stool lands ni alo Sempe Kometo stool lands ni. So once again, nakambia me there was the Trinity. Remember the Trinity. You remember the Trinity? Alata akomaji kesempe. So ani akola chefele fan akenaken shipon ni yo jeme Jamestown as the Trinity amame no alo Sempe Kometo no. And that is the distinction ni ata oni afe clear. Whether or not the respective parties to the consolidated action are each entitled to the respective reliefs claimed in their respective pleadings. The later trial judge, having evaluated the evidence laid on record vis-a-vis claims each party pleaded, came to the conclusion that the Sempes too were unable to prove their case. Accordingly, Akolache J dismissed the counterclaim Sempes too mounted against the plaintiff and co-plaintiff in the case. See Akolache J's judgment at page 21, volume 2 of the record of appeal. So, Judge Nchonagadabi, Sempe me ni ameba joining suit. Amenye ame prove ame case ojuba. No na biwe mo na amekabale nche Akolache ewo echafun. Now, Akolache J, Justice Akolache, having dismissed the counterclaim, it is an ideal statement and very simplistic. An argument that Sempes too owns the land, the subject matter of this suit, or was given any possessory rights thereof. Admittedly, it is on record Sempes too granted a lease to a portion of the land to the Agricultural Development Corporation to operate poultry and other farming related activities thereon. Akolache fele clear akenagajeme, of course, Sempe Jimeni amekeha. So even though Akolache admit ake Sempe Jimeni ameke lease government they have no possessory right to Nakan land there. However, it is straight law that one cannot give what it does not have. Nemo that code non-habet rule. You cannot give what you do not have. So if it's been proven or if it's been stated, okay, you have no possessory rights to the land, you have no authority whatsoever to give that land out. Nemo that code non-habet. It is imperative to observe that the three stools, namely Alata, Sempe, and Akumaji, contested the case. The established evidence that emerged in the trial was that all the three stools were subjects of Jamestown stool. Akolache, in his bid to do justice in the matter, applied the principle enunciated by the Privy Council in Anege Akwe versus Manchekojo Abebio to the Niya Oduade Crab versus J.A. Kwe case, as stated before, and held that the subject of each quarter has the right to occupy vacant stool land, not effectively in occupation of one quarter or the other of the land known as Jamestown land. So achonage nege case name achonage yes nege me tenefe achonage mokome potential pon neshimon keji moko ye ekwe Akolache kwano ne kaka okay bono ne. You understand what I'm saying? But because I'm a jamomo na I think ake kenya ba kai I'm a chele noko rule ake e bagamashi case say so the way ni a dealer with one land issues fe adanoko there was a rule ni court say a create a gamashi b, and that is what affected nekenoko ne. I think it will be mentioned here. I mentioned the enemy the subsequent show say on this case the principle enunciated by the Privy Council judgment number 101 of 1924 in Anege Akwe versus Manchekojo Abebio Supra is to the effect that by custom of the tribe, land that this is what I was talking about. Land which had been exclusively used by the inhabitants of a particular quarter belonged exclusively to that quarter. It was on that account of that principle that Akolache Justice made a finding of fact that the stools involved in the contest belong to the traditional area of Jamestown, which comprises 3 quarters, namely Alata, Sempe, and Akumaji, in Accra on east of the Koli Lagoon. Undoubtedly, at the trial, Alata and Sempe stools were the real contesting parties. The main issue in the consolidated case turned on which of the contesting parties had allodial title to all the quarters' lands collectively known as the Jamestown stool land. At the close of the trial, Akolache J held that each stool are their subjects in occupation and use of their respective portions of the land was the owner of the land their subjects occupied. Being dissatisfied with the judgment, the Sempe stool appealed. So once again, ni Boni Akolache Gbawe akenakan because Gamashi neke jiboni adekemoko ewebi ye jemeke jobu ade na gbla mi na kan jiboni afiole Sempe me amenu shishi amenta oni ball afele fan no ame appeal wakwano ni teno. On appeal against the judgment of Akolache J, the Court of Appeal overturning the judgment held the test the trial judge employed could only be resorted to where there was doubt as to who the allodial owner was and where quarters lands were in question. The court therefore held that the trial judge had erred in assuming that quarter lands were in issue while they were not. The Court of Appeal then varied the judgment of the trial court in favor of the Sempe stool by deleting from the judgment the parts which had apportioned various portions of the disputed land to the plaintiff and the defendant's stool. So actually the Court of Appeal actually wage noni jeje dubono ne eke bla na kai no je na kai ni Sempe me nikete appeal no wo ajieno yemi Court of Appeal jieno yemi. The decision of the judgment was also subject to an appeal. So Bolly, I appeal the same thing. Now let's go on. On further appeal to the Supreme Court, the Apex Court held, allowing the appeal and affirming Akolache J's judgment that the history of Jamestown showed clearly that it was constituted by 3 quarters, namely Akumaji, Alata, and Sempe, and that their property was vested in the Jamestown Manchester. Each quarter could only claim ownership to an area, which was in its exclusive possession. It would therefore be wrong for any of the 3 stools to claim for itself the allodial title to all Jamestown stool lands. The Supreme Court held further that the trial judge had used the correct test in arriving at his conclusion. So, noni kanene, so keji, Akolache yuena kai, ni aba anushishi, ake nakan jeme, nakan Akukor Foto, no, Sempe ma no na anushishi. Why are we here? I'm not a lawyer, I'm just asking. Bona, yes, Sempe nye claim allodial ownership to Jamestown stool lands. She tumoboni I used to test na kan gamashi test na use where ni ke stool ko we be ko for a long time. Ni amame use for a long time. I call ake na kan pono mi amame no ni Sempe me Akukor Foto for a long time. Ni ame claiming for a long time. Why is this now? I'm not a lawyer. I'm not saying who is wrong and who is right. I'm just reading. I'm just asking. Boni wakandi ole. Because minkabofe ordinarily calling na Akukor Foto jemi. We've always assumed that na jemi Sempe ma shikoni. You understand what I'm saying? We've always assumed na Akukor Foto ma jemi Sempe ma shikoni. So kaji na can test G noni ayuso te balete ni anyways. Yes, I rule against Sempe because Sempe claim na can jeme fe. You understand? And of course, they wanna rule against that man. Over there, Jani Femo, Kiamoko ni Okiamoko. What be now? What time? Let's go on. Although the Supreme Court acknowledged the finding made by the lower court that all the 3 quarters are entitled to occupy any portion of the Jamestown stool land where the subjects have reduced those portions to their exclusive possession, the Apex Court, per its judgment, never affirmed any possessory rights in the Sempe stool. So, no, you know, you are, even though I know shishin, na kake, keji obi ehimbiye ni ame duni ya jeme ame njeme keja obu ade no ewo obanyo ka ke bo no ni hankobo processory rights ni twa kebe oba call fala. So Supreme Court there failing again. In any event, the Akolache J's judgment was specific that the Sempes too were unable to prove their case and therefore went ahead to dismiss their counterclaim. So this is what the judgment is saying. Okay, Sempe me amentani akake na kan shipon amenoni fala. Even though judge allo neke judgment ne kake yes because I'm a webi in Jeme amanya me kaka ameno akaka amenoni fala. Aye ame de kula from the alatas too. You understand what I'm saying? In any case, the Akolache J's judgment was specific that the Sempes too were unable to prove their case and therefore went ahead to dismiss their counterclaim. Consequently, at the risk of sounding repetitive, it cannot be right or correct to say that the Sempes too was granted some possessory rights. So once again, because of Nakan judgment, Sempe too nye kake nakan judgment ehame possessory rights ni twage nakan judgment be amame no kla till thy kingdom come. So obakwa ke abawe boni ebale ni gbawe hu bakọ nakan judgment umbo because kaji aye nakan sande judgment with Jamestown alatas too say ngbe gbawe hu jo na eba mi. So obakwa let's go on. It bears emphasis that in the present suit, the plaintiff, in proof of its case, tendered in evidence as Exhibit G, a judgment of the High Court Accra, presided over by Victor Foy, as he then was. See pages 39 to 97, volume 1 of the Records of Appeal. The judgment was in effect of Akukor Foto land, the same as the land, the subject matter of our present suit. They did not appeal because ni adoto tinto afe deal ko yese no you know ne gbe ameshibi ane ame appeal neke Victor Ofoe judgment ne nkwe shukwe eba wa me amesane na me yo. Now I believe the status of limitations expired. I don't know. So I don't think they can go back and appeal this case. Why they did not appeal? I know. I have in your video going to get chombo back border. She I came again get chom. Bona anybody when you are a journalist, your sources must trust that can be careful no go. Hold on to it. Bona ni and deal kote no wani nega appeal afi. I think it has gone along. It's contributed to the defeat. Now, the principal parties in that suit were the Sempes too and the Adam Kwate family of Gbawe. In a consolidated suit with the title and suit numbers, respectively, was Ache Nomejona Abie Niadoto Boa Plaintiff versus ICOM Limited, ICOM Estate Limited, IK Mafu, Niadam Kwate, Nia Yi Kind Third. And suit number Lojino be a Niadam Kwate, another one versus ICOM Estate Limited. Edmond Kofi Sowa, Ni Adotobo. In his introductory remarks, Justice Ofoe, as he then was, observed that a consolidated suit in question concerned a piece of or parcel of land popularly known as Akukor Foto, located in the environs of Dansoman and Odoko. The description of the land in the first suit, L215/2001, was given by the plaintiff as 36.26 acres, whilst in the second suit, AL23/2003, the size of the land was given as 9966.81 acres, almost 1,000 acres, or 4033.37 hectares. In suit number L215/2001, Sempes Stool, as the plaintiff, claimed to be owner of the land in issue, that it had conveyed the land by a lease to the Agricultural Development Corporation, ADC, on 12 January 1960. According to the Sempes Stool, the lease had expired and they had re-entered, but the first, second, and third defendants had, without their consent, entered the land, cleared a portion thereof, bringing construction buildings thereon, and installed guards and other workmen thereon. The fourth defendant, the Gbawe Kwate family, had claimed ownership of the land. But then, when all of them had ignored various warnings to them, the Sempe stool caused a writ of summons to be issued against all the defendants in that suit, claiming A, a declaration of title to all that piece of land described in the schedule annexed thereon. B, recovery of possession. C, general damages for trespass. D, mentioning profits and perpetual injunction. The fourth defendant, Adam Kwate family of Gbawe, had claimed that the land in dispute, popularly known as Akukor Foto, falls within their family lands and described the boundaries thereon in their statement of defense. The fourth defendant then counterclaimed as follows: declaration of title to all that piece of land situate and being at Gbawe, ko enyo na. So any fail or Dubai. First one be not type le no in chele e conclude. And commonly called Akukor Foto. So Gbawe be amechole ko enyo na. State poultry farm in the Greater Accra region containing approximate area of 36.42 acres, etc. 2. Recovery of possession. 3. Perpetual injunction. 4. Further or other relief as to the Honorable Court may deem fit. Now, in the second suit before Justice Ofoy, as it then was, namely L219-2003, AL23, the Adam Kwate family also claimed to be owners of a large tract of land, part of which the Akukor Foto land directly in issue formed part. They described the land in paragraph 2 of their statement of claim and accused the Sempe stool of trespass. Ni Adote Obua II, representing the Sempe stool in that case, also counterclaimed against the Adam Kwate family as follows: a declaration of title to the piece or parcel of land, the subject matter of the lease between the Sempe stool and the Agricultural Development Land ADC dated 12 January 1960. An order of perpetual injunction restraining the plaintiff and the defendant, etc. C. Another order upon the defendants to pay general damages for trespass. Having considered the pleadings, the parties filed in both cases, Judge Ofoy, as he then was, observed that the pleadings in content were not different in substance, the claims of each party in those cases. The learned trial judge, after critically evaluating all pieces of evidence offered at the trial vis-a-vis the pleadings the parties filed, made some pertinent findings. He held, for example, that a purported lease by the Sempe stool to Agricultural Development Corporation is invalid, or was invalid. Really? Okay. So, neke noni waliake Akukor Foto Sempe meji meni amekenya state farms ni ayusu for an poultry farm. Judge Ofoy chono age ni akeneke sanene tejame because ba we be a bon jame ya ni adoto obuwa unke take out ake kaja 1960 ton wo ke shpone lease government Agricultural Development ba wo ke lead ya me ni ameke fe poultry farm ye jame te fe oten ni ba we be nye ba mi jeje yue ake ye enikpa mo mi ne ko na ake da bi neke lease ne ni Sempe meke ha Agricultural Development Corporation na kan no eja. The late trial judge explained at page 89, volume 1 of the record of appeal that the Sempe stool was unable to establish their title to the land, apart from their reliance on the lease to the Actual Development Corporation, which lease he held to be invalid. So, Judge Nchono Gwake, once again, Sempe me, na kensani amiye, ame title to ame land there. Sempe me nye presenting no koni chwanke na kenshikpon lele ama amenoni fe neke lease ne ni ameyo ni amekeha meni amekehane amekeha Agricultural Development Corporation. So apart from lease, Sempe menye prove documentarily ake they have title to that particular land. All right, let's go on. Also, page 96, volume 1 of the records of appeal. The learned trial judge in his judgment held that the unchallenged traditional evidence of the plaintiff, Adam Kwate, was more probable than Sempe's two. Okay, lele traditional evidence. They drag about basan in the shippo or no ni wafeneke, wateneke, wakume feneke, wacheme feneke, wafeneke. Ameno ni abotue, jajake, ehenwa womi, fenoni Sempe me by yue, ye neke sandene na yen. He was emphatic that Akukor Foto lands falls within the large tract of land Gbawe claims. Ona English alata, ona nyemineja, ona ge egbanyena. And he can acquire nine English alata stool, nye yete ni nyemieja, can acquire nine Gbawe be by na can shiko GFE. Ona ekome femo. No mi wale yo. Bona, can you acquire nine Gbawe be a by hen shiko GFE. If at all, nyenyenoni, Gbawe be by ve. Nyemiete neja, you understand? Imagine me I present case ne for English yala the Jamestown stool where ni clearly a kolache kake allow their ownership yana kan jeme it belongs to the Jamestown stool. If I'm reading it right, I may be misinterpreting what he said. You understand? So instead of me an individual stool to Sempe allow danso allo akamaji, allo bueja, I'm about fight for nekeshipone. Imagine only there is a case being presented at the Jamestown stool. You understand? And I'm making this conclusion based noni akolache ehani wana. Ona. Right. So let's go on. In his view, by the traditional evidence, the plaintiff Ni Adam Kwate led at the trial, he did establish a better title to possession. The trial court on that account preferred the story of Ni Adam Kwate to Ni Adote Obuos. So once again, Sunday, Ni wacha Ni Adam Kwate Bagba, Jeje Heno Eye, Feke se ni a presentee on behalf of Ni Adote Obuo. Now, in the final analysis, Judge Ofoy dismissed the plaintiffs, Ni Obua the second case in the first suit, but upheld the defendants, the fourth defendants, Ni Adam Kwate. As regard the second suit, the court found for Ni Adam Kwate, the plaintiff, and dismissed the counter claim mounted by Ni Obua. So on any Sempe me ame lose case ton. Crucially, although the Sempe stool filed an appeal against the judgment of Judge Ofoy, the appeal was struck out by this court for want of prosecution. So once again, if you so Sempe stool na na judgment ne ame file appeal ni ame shiang me so I strike it out for want of prosecution. The Sempe stool therefore lost the opportunity to have the decision of the lower court overturned on appeal. You see? Bona. Ona me lose case here ton. Ninkebu ake last year judgment ne jekoye high court ni danso ke Sempe jeje make the same reference ake if me na pe no ne wo ni Sempe me appeal. So you see any Gbawe bi e call amesani ekejo. I'm appealing, they didn't follow up. So I strike it out for want of prosecution. I strike it out. Leadership. It's very, very important and very, very critical. The legal effect is that the decision Judge Ofoy, as he then was, is of potent legal force and binding on all the parties in those. Yeah, me 1 second. All the parties in those cases, their previous successors entitled agents, etc. Therefore, I do wrongly agree with the submissions of learned counsel for the plaintiff that the lower court erred in law when, although it has held that the plaintiff was entitled to a declaration of title to the disputed land, it refused to grant plaintiff recovery of possession. In the circumstances, I resolve the plaintiff's fourth ground of appeal in its favor. I hold that Akolache J's judgment never granted possession of Akukor Foto land to the Sempes too. I dismiss the defendant's second, third, and fifth grounds of appeal for lack of merit. I now come to consider plaintiff's first ground of appeal and the defendant's fourth ground of appeal together. From the available evidence, it is not difficult to find that the defendants committed trespass onto the plaintiff's land. The first to fifth defendants, for example, had pleaded and admitted in their statement of defense per paragraph 18, page 165, volume 1 of the ROA, that they have started constructing buildings on the disputed land at the time the plaintiff instituted the present suit. So once again, I may admit that equally, the sixth defendant in this defense pleaded in paragraph 6 thereof that when she started her building foundation, the plaintiff reported the matter to the police, but the sixth defendant decided to continue with the development on the land. Nonetheless, CSP 192 volume 1. Once again, ke oboin oeshipon inyeme mansebi oeshipon ni ochashipe ni mokoba ne kebwa ke ne le no ni ofaine kama mashi ke wajeme. These people will tell you ake kafwe da ya no ma boy ya lo ya ma dabi kama because ko e abani no ya jemene ma position mi e o shika no ba fite no ba ma shifen aba kumole tumono no na kumole so no chashipe ni a report ke the police station na ke ba ke apele shipon e pe e ke kama niemo shika because shiama ejala wa fe shipon o ba shipon $5,000 show ba fite $100,000 no ko ba ma ekeka ye money ho shipon abo aba kumofen ashwe. So fine once again ke ochashipe ni mokoba ni mo ya report ke the police station ne ka shipon no ni pe ka cha no ko for wall ni mokoba ni mo ke shipon no for wall no ni ke no kwa kama no mena yesani atadan. You'll be better off leaving it kwano ba shipon ye conclude ni sani bay. Once again, man sebi nya wakasi ani ye ne cases na mi. Nya wakasi ani. Ke wakane ni wakane ni bi ni yo mi nya wakasi ani ni wake because ayo wa we wa when cases ne aka yo wa we obega no ba nye court. Obega ni bolencho ba nyo sande mi. Be no ba na onye snow mi. Be wo shika ke yashia ba fite. So mi kwanye fire ye shiba mi. Once again, nya ni wakwa wo man se biye nliaga mani me hwe na me nkwa titiri man se bi so Ghana biele no nin kan yo ne je ameza na me fa me shi no wo man se biye na hwe woni won kwa nya ni wakase ani yemie nya wakase ani yemie shi ba mi Ghana biele boli ene me echi ame botu The averment herein referred to buttresses the plaintiff's claim that the defendants are trespassed onto each land. The plaintiff's representative, Reverend Sami Ajipon, in his witness statement filed with the lower court on 7th April 2017, appearing on pages 254 to 258, volume 1 of the Records of Appeal, had particularly in paragraphs 11 to 15 averred as follows. My lord, the land in dispute had been in possession of the plaintiff without any confrontation from any member of the Gbawe family or the plaintiff's sub-lesser until sometime in the year 2010 to 2011 when I realized that the 8 defendants encroached on a portion of the land. 12. I realized that the 8th defendant, just like the rest of the defendants, had commenced putting up a building on a portion of the land. I was able to take pictures of the 8 defendants' illegal structure on plaintiff's land, and same is attached as Exhibit E1 and E2. 13. I then drew the attention of the 8th defendant to the fact that the plaintiff is the legitimate owner of the portion of the land he is unlawfully developing. But the 8th defendant ignored my information and flagrantly continued to develop the land with assistance of armed land guards. There you go. There you go. Armed land guards. There you go. That is their modus operandi. 14. I therefore instructed one other staff called John Ajipon to report the 8th defendant to the property fraud unit of the Ghana Police Headquarters, Accra. The police advised all the parties to halt their activities on the disputed land since the case is before the court. 15. The 8th defendant ignored the advice of the police and put up a 2-story building with the help of the armed men. So, you see, presently, the 8th defendant is using the said structure for commercial purposes. Find the attached a copy of the police report dated 25th February 2015 as Exhibit F. Emphasis added. It is worth noticing that a considerable part of the arguments of the defendants before this court in this appeal was concerned with the registration and issuance of the land title certificate to the Alpha Beta Education Center Limited, claiming that the plaintiff obtained it through fraud. Indeed, the defendants, per their counterclaim, sought 1. A declaration that the purported plotting of 8th defendant's land in favor of the plaintiff in the records of the Lands Commission was procured by means of fraud and or based on false representation. 2. An order setting aside the supposed land certificate number GA38589 dated 8th May 2012 as same was procured by fraud and or based on false representation. Consequently, the defendants claimed for an order directed at the Lands Commission to expunge from its records the land certificate number GA38589 in favor of the plaintiff and or anything incidental thereto. Having pleaded fraud, the defendants carried the burden to prove it. 4. It is provided in S13(1) of the Evidence Act 1975 NRCD 323. In any civil or criminal action, the burden of persuasion as to the commission by a party of a crime which is directly issued requires proof beyond a reasonable doubt. Where the defendants are able to prove fraud against the plaintiff, the law relating to fraud and its proof in civil litigation is already overburdened with fine distinctions. Suffice to say that on general principle, fraud violates everything to the extent that even the solemn judgment of superior courts may be called into question as having been obtained through fraud. The Supreme Court, speaking through Justice of the Supreme Court Akwa, as he then was, stated the principle in Frimpong versus Nyakun 1998 to 1999 734 at 743 that fraud vitiates everything, and that when a court of law in the course of the proceedings has cause to believe that fraud has been committed, it is duty bound to quash whatever has been done in the strength of that. Right. So court nanoko ni later anya prove ake no not through fraudulent means about na chafu. It is duty bound to quash whatever has been done. By rule of practice and procedure, fraud has to be pleaded, particularized, and proved strictly. Where fraud and duress were pleaded, particulars must be given. Consequently, where no particulars were given, it must be taken that either no fraud or duress existed, or the averment amounted to a mere denial. See Daba versus Ampa, 1989 to 1990, First Ghana Law Review 598 CA. That's on general principle. The court is not to find fraud unless particulars thereof have been distinctly pleaded and proved strictly. For a finding of fraud is not to be made without clear and cogent evidence upon the subject. So once again, yes, the defendants are claiming the plaintiff, in this case, Alpha Beta, I may acquire title to the land fraudulently, but bonini a yo legiake. I may jimeni esani. I may prove your jogba ni kotu ane liake leleng. Neke title ene Alpha Beta na Alpha Beta inale fraudulently, and therefore noni eba clearly chonke amenya ame prove ake neke title ne Alpha Beta na through fraudulent means. Now, in answer to the question raised, Supra, as to whether the defendants proved fraud against the plaintiff, I find that the defendants wholly failed to do so. So, I may raise the fraud, but they were unable to prove title ni amena through fraudulent means. The litmus test of proving fraud is proof beyond reasonable doubt. In the first place, from the available evidence, the plaintiff took the grant of the land, the subject matter from the rightful owners of the land, the Ni Adam Quote family of Gbawe, as Judge Ofwe. Once again, why did the Sempe stool fail to pursue appeal in there? I don't understand it. As I have profoundly stated in this judgment, Justice Akolache's judgment never granted possessory right to the Sempe stool. Go back. Akolache never granted possessory rights to the Sempe stool. Neither did the Supreme Court affirm any such possessory rights. Next, in the present case, all parties are deemed, as of today or to the day, that the disputed land is situate and lying at Akukor Foto. Insofar as of judges Ofwe judgment found for the Niadam Quartel family of Gbawe, the grantors of the plaintiff, the grant to the plaintiff hearing was proper, because once again, the Sempe stool did not follow through with their appeal of the judge Ofwe's judgment. It follows, therefore, that the plaintiff's subsequent registration of title to the land and its acquisition of land title certificate issued by the Lands Commission is, to all intents and purposes, valid. It cannot, by any stretch of imagination, be said that acquisition was fraudulent. There is that overwhelming evidence, also on record, to show that the defendants went onto the disputed land and called the bluff of the plaintiff when it was demanded that the defendants remove themselves from the land. Indeed, in their respective statements of defense, they admitted and boldly pleaded that they would continue to develop or construct their houses thereon regardless of the pending suit. Once again, Akuje, in the nation. Thank you, Akuje. Once again, Kabo Manchakutwe until Obana proved beyond reasonable doubt. You understand? Akuje yani na liake ni Sempe majeno ko ni akehami so ke makwe ken ke ba there will be a part oba fe show ye. So I think I get oba kwedo ni jikeke wani nyele wabani nyele no fe no. You understand? But okay, it's 13 pages long. I think I can peel it. Okay, got it. Right. Thank you, Akuche. Ina. So nyani wafia careful. What man say be link panify. Nyani wafia careful. Nyani wafia careful. Wafe wale bonika shikonji insane ba wamajiancheme yo. Like I said, onage mofe mwete. Nke wai 40 nation ni wako. I guarantee you wafe man say be son. Because any me nyawo she be ele dabi abeja me san wo mani woko e show woman ameshi woman say be pe ni won kan de no kone and I'm glad because nekini bi na affect woman say be wa so nya ni wakase ani yemi ni bi ni jiokpo ye ne cases na mi ani wo fio ni waka fam wo na jinkaji ebaleshi ama ke shikon sane ye gan wakwano ni wakaya. Now let's go on. In law is an act by a party done inconsistent with the right and quite enjoyment of another's property. Trespass to land was actionable per se without proof of damages, and the result, I resolve in its favor the plaintiff's first ground of appeal that a trial judge erred when, after affirming that it was entitled to declaration of title to the disputed land, refused to grant it the relief of possession. Once again, following this, I dismiss the defendant's fourth ground of appeal as unmeritorious. The ground is that the trial judge erred in holding that the plaintiff was entitled to a declaration of title to the disputed land. Resolution of the second suit. I quote suit here. In this other case, the plaintiff had sued the first to 8 defendants for a declaration of title, damages for trespass, among other judicial reliefs. It is common cause of the defendants in this case, just like the first suit, IA suit number FAL/558-2014 Alpha Beta that the plaintiffs had acquired the disputed land not from the rightful owners. Additionally, the defendants contended that the plaintiff obtained its grant of land and the land title certificate by fraud. The defendants also called the bluff of the plaintiff, contending that they acquired their land from the rightful owners of the land, the Sempe stool, and that regardless of the pending suit the plaintiff mounted, they would continue to build. Significantly, the Sempe stool claiming to be rightful owners of the land, the subject matter of the suit applied to be joined in the suit. The stool represented by the 9 to 11 defendants mounted a spirited defense that the Sempe stool, as the rightful owners of the land, once granted the land to the Agricultural Development Corporation for poultry farming and other farming related activities. Once again, I think I get a lot of me. Look, I'm not a lawyer. Once again, I will never play one. But clearly, a lot of mishaps on the side of the Sempe. Just reading this appellate court ruling there, I think I can. Anyways, let's go on. Additionally, the stool claimed that per the judgment of Akolache J and affirmed by the Supreme Court, they were declared owners of the disputed land and given possessory right thereof. In that respect, the 9th, 10th, and 11th defendants counterclaimed against the plaintiff for a declaration of title to the disputed and record of a perpetual injunction, etc. Given the two diametrically contradicted claims by the parties, the court called upon to determine the effect of Akolache J's judgment and as affirmed by the Supreme Court on the present case. Now, having regard to the fact that the parties were dim as to the identity and location of the disputed land and the facts and evidence established in the first suit, i.e. suit number FAL/558-24 Alpha Beta are the same or all on force with the second suit, I do find that the story of the plaintiff was more probable than the defendants. The decision in the earlier consolidated case Judge Akolache tried has no bearing on the question presented for the determination in the instant appeal. So once again, the Akolache judgment, look, even though if ever Sempe be in any way put the enche based on the understanding of the law, evidence not getting me here, if ever in any way clapo still if feel like a Akolache no abanya use Sempe me banya use ni amekefe. At the risk of sounding repetitive, this court is unable to accept the argument of the defendants that the Sempe stool were declared owners of the land and or were given possessory rights of same. So court take that be ake Akolache fele fan ake nakanshipon ama Sempe me possessor. Mind you, judge court shishunomo from Akolache judgment chono kwake ayake nakano Jamestown alata no aye exclusively for one stool or the other. So Sempe kometo nye kake they have possessory rights to nakanshipon. I may be wrong with the way in Nushishi. She born in Kanye no chon nakai. Even though a grant take admit take yes, ke obale machine boni waja wa shipon nakai. Money it will be eyi eko kejo boade na ba anya trace nakai mo ambanya me kaka ma meshiponi. So Sempe me ba anya kaka ma meshiponi because I may will be a in Jamaica job boade shimo nakai Jamestown alata noni. You understand? Once again, so imagine money nakai Trinity a break iko. Instead of Sempe kometo ni a fighting again okwe fight in the name of Jamestown Alata. You understand what I'm saying? Once again, I'm not a lawyer, but this is my understanding of Noni Inkane name. Okay. I also find I also find that the land, the subject matter of this suit belongs to Ni Adam Kwate Quality family of Gbawe. Ni Sempe, why in appeal? Wolone chono wakenye appeal. Sinye pursue don. No, I strike out for want of persecution. So my question to Ni Sempe is that me no ni ame appeal judge of judgment ni ame follow through don. I'm a lawyer and a failure me. And Ni Sempe ana can send me. So makande mabu nkonyona because I mentioned here not today. Mene wa for 3 hours almost on kane. Show ni makande konyona. Ona Ni Sempe ke ana ke ami makande konyona. But unless noni a capture a be it is wrong. Okay, you follow through Judge Ofwe's judgment appeal nye fee say don nye say don ni a strike out for want of persecution. Bona. So we'll see. We'll read it. I'll read it for you. Nkeba makande mabo. Ni mo femo ana Ni Sempe me ameno no mo ene konike ba she wono wo ka no. You understand? Ni mo femo ana any ishipon ka ene boundary yo. Konike ba she wono wo ba take on the realms of affairs say ni wo kwebo ni wo ba afa ni wo ba chigan ke anye. Neke shipon no mo ne egbla wo say. It's too much. It is painfully obvious from the available evidence learned on record. It is painfully obvious that the defendants committed trespass onto the land, the subject matter of the dispute, which have held to belong to the plaintiff as the right owner thereof. On the claim of general damages for trespass, there is an overwhelming evidence established in the case that the defendants entered the disputed land and the plaintiff reported the matter to the police, and the police warned them to abate the construction activities they were carrying on the land. They ignored all warnings and continued to build. That is clearly trespass onto the plaintiff's land. Once the plaintiff has been declared the owner of the land, the subject of this suit, it is tried knowledge that trespass to land is actionable per se without special proof of damages. See Bamus versus Mensah before. In law, possession was not in the popular sense of only physical occupation of the land, but some other acts done which identifies a person with true ownership of the land. For example, by receiving rents and profits or has the right to receive same. See Akoto versus Jemfi Ado, 2005 to 2006, Supreme Court Ghana Law Review 1018. I equally hold that the registration of the land by the plaintiff and the subsequent issuance of the land title certificate by the Land Commission to the plaintiff was valid. So title any defendant say ke plaintiff acquire fraudulently jeje ke dabi. Ni declare ake lele ni Adam Kwate wekue amame shikpon nie be title ni alphabet nie eji title pakpa ame hele through fraudulent means. In the result, I dismiss the grounds of appeal the defendant filed. That leads me to addressing the final ground of appeal that a judgment of the lower court is against the weight of evidence. Final ground of appeal. Judgment against the weight of evidence. A judgment is said to be the weight against the weight of evidence, where the trial court has misapplied some principles of law to the evidence, or whether the court has failed to draw an irresistible conclusion from the evidence. See Fofi versus Zanyo, 1992, Second Ghana Law Review, 475 at 490. So judgment co is against the weight of evidence. The judge co apply law wrongly. Allo a follow evidence or evidence ni akenhale ni ekeye na kansanie. Where the findings are clearly unsupported by evidence on record, or where the reasons in support of the findings are unsatisfactory, the judgment is said to be against the weight of evidence. That was the principle of law stated in Chiafi versus Wono, 1967, Ghana Law Review 463 at 466. The case the case Robbins versus National Trust Company 1972 AC 515 also illustrates the legal principle that a judgment is against the weight of evidence if the findings of the trial court were demonstrably unsupportable. Traditionally, when an appellant claims that a judgment is against the weight of evidence, he implies that there are pieces of evidence on record which, if the trial court had properly applied them, would have changed the conclusion it's reached in the matter. So once again, Judge explain Kakenoko is against the weight of evidence. And I can once again, Judge any bata sani no kaji question ni miojugba ni eje based on evidence ni akeba boni eba musani na it will be different. You understand? So Nakanjina, the appellant therefore carries the burden to demonstrate precisely and clearly where the court below erred. So Judge Nchono kwake so ke bale na kan bomoni oka appeal ba na yesane abu ni bo feel like Judge ni yesane e kwa evidence na kan nwenye na yo aye lojuba benuele bo jimoni na kan no sa ake bo o prove ake evidence no kete no feel like sani Judge akono na e yesane abu e kwa na kan evidence no. Put differently, the appellant shall clearly show to the satisfaction of the appellate court the lapses in the judgment being appealed against. See Jean versus Musa Bakun, 2007 to 2008, number 1, Supreme Court Ghana Law Review 686 at 687. In Takrade Flour Mills versus Sempe Farms, 2005 to 2006, Supreme Court Ghana Law Review 882, 887. The Supreme Court, in articulating the duty cast on the appellant who claims that a judgment is against the weight of evidence, described as follows. An appeal on the ground that a judgment was against the weight of evidence cast a duty on the appellant to show that the conclusions of the trial court based on deductions from the pleadings and the evidence on record were at variance with each other. The applicable laws were also wrongly applied by first the trial court and then the court of appeal. So nothing black you have to prove evidence and no keba. If no ni an omnibus ground of appeal that a judgment is against the weight of evidence derives its strength from the general requirement of law of proof in all civil cases. And a party who carries the burden of proof must establish a preponderance of probabilities in his favor. Otherwise, he fails in terms of holding. That is to say, the party has a duty to persuade the trier of fact that his case is more probable than his adversary. From the available evidence led on record, I hold that the plaintiff was able to establish its claims in both cases that were consolidated and was therefore entitled to judgment. This court, being an appellate court, it is within our province to reverse findings of the trial court which are erroneous and or unsupported by the evidence on record. See another holding kage holding no know na cases na ni no me authorities said the way na male document may becomes holding no you know that let's go on. On the strength of the judicial authorities referred earlier, I hereby set aside all erroneous findings by the lower court in the instant appeal that are not supported by the evidence led on record. One of such erroneous findings is that the plaintiff was not entitled to recovery of possession on account that Sempe Vrs was granted possessory title to the land when the evidence was rather that Akolacha J dismissed Sempe Vrs counterclaim. The court has also erroneously held that the Supreme Court has affirmed possessory right of the land in Sempe Vrs when that holding was unsupportable. I resolve in favor of the plaintiff the omnibus ground of appeal that the judgment of the lower court was against the weight of evidence. Consequently, I allow the appeal and hereby set aside the judgment of the lower court in its entirety and make the following consequential orders. Title to the land, the subject matter of suit number FAL/55A/2014, Alpha Beta Educational Center Limited versus Nana Osai Bonsu and others is decreed in the plaintiff. So title is Amena JJK Nakaino. I equally decree title to the land is suit number LD 0794/2016 Alpha Beta Educational Center Limited and Mama Mercy and others in the plaintiff. I order recovery of possession in favor of the plaintiff of all those pieces of land in both suits which the defendants have trespassed onto. So this is where ni Alpha Beta banye kake I'm demolished because I can't recover I'm shipon. Of course, the counterclaim from Sempe is that even at an appellate court no can what am the Supreme Court no mabo. Even at the Supreme Court no I may call for a review. So it's an no ameda and we will ask our lawyers whether na can abanya feel and can down. I grant perpetual injunction in favor to the plaintiff in both suits against the defendants, their successors in title, previous agents, workmen, etc., from dealing with the land and or doing anything inconsistent with the plaintiff's quiet enjoyment of the land. I make an award of 40,000 cedis, general damages for trespass against each defendant in both suits. Cost followed the event. The plaintiff/appellant is awarded 100,000 Ghana cedi cost as offered by counsel for the defendants/respondents. Signed, Bright Mensah, Justice of Appeal. Signed, Henry A. Kofi, Justice of the Supreme Court, sitting on this case also as an appellate justice. And Janapari Battles Kojo Mrs., Justice of the Appeals. Edmond Opon, Nana Efa for plaintiffs as appellants, so lawyers say can he be any audience. So, once again, the Sempes 2, I believe they are I may follow through with the appeal. No jinoni eyame awi be Judge Ofoe's judgment no ani Gbawe bia because Judge Ofoe ke Gbawe bia sanye na meyi ne ha me akelele jema ma me no ni clearly Sempe me appeal because I can send me she tumoboni judge ke ni ame appeal I may follow through yani wo ke akuche ke waka akuche ke ayabache abakpano ni wokwe boni woba gbena wo ha and of course keji otawni owie noko obanyo text high keke nkeba once again boli negeni nkande mone boring but it's ani wofi ona boni ni yo we have to do it koni ekashi for the record ona boni ni yo so there you have it in appeals court no ne wo oba face Supreme Court now oba kwake wo ke Sempe ma appeal ba fita ilo even though I may pursue you, so we'll see. Akuche yeah nyemi to your tay
no do na ale go side there
you wa domo o fane what can electoral onu ni BP na ge ni Sempe reach out to you so far miniji no no ba you no ni what can electoral na
oh niele wake boni ni etele ogbla no fia no mi fine o am fia mo
right
odo be shi na think aga shi ikashi ake be to bono ojenshi no wie ake isani ni Sempe ita ikashi ye no ko na ikura ona bia na ye ni e she isani no mo tashi ye kula ne wo ya sani ye ni fe ne ba chon ni ibanye eche ne gba ni na se sani enye eche ne gba ni na se because wo le no kan e fe if it mo ama me ye upper hand omo eji gba we bi ye ya ga ni Sempe hu ni bi ko meni etano di se onumishi ya di se ni nli akashi ele ake na kan ni iba affect le bia ne onumishi ake no le no ma be ko em go flag show ene je no ko ni be so ake ona shi ke ibale court sani e mi no ni pe ma yu pe ni inu mo ekwo no be no opinion fe ekwo no e ke na kan ni be fe se ni mi ni
that's right
no kan yo fe ebo fe to ni ekwo no onumishi ona ni pa fa ke ibale court sani kan ni bi ele akwa chafu go kra be mi no ko bi oni on presani enye edomoshi
right
ojogba
right
sani ke numo ba nye ni bi fe ye ni wa chese ku Sempe ba nye question back
yeah okay so okay
yeah
okay
so
noni ni Sempe ke send bondo ke ambi ane no min kan this was another case at the Supreme Court ni if you market no so it's okay so we'll go into this case in the Superior Court okay in the court okay so in the appeals court okay so we'll go into it ni work judgment to go back that's right
enoni le yen ni feel like she no domo
that's right that's right
that's right as time goes on can be come ye hu ye sure ke numu iba wo because that fact le we le no ni na ni normal okay le we le no ni na ni normal
so oba kan no ni Sempe ken awo ne oba kan no nyega ya anyetwi oba kan wa anye ni nye na no fe no ni yomi yeah
na kan ona ni ko ni akwe because ke numu like boni we chale obi la ami ko upper hand no mo onumishi ni ake ona ke gba obi wa mi face smart na mi ko no na mi ho ami amoko ona woni ami ho ami amoko woni afetu mo 2 against 1 bi ane ona ni won pa o che fa e ka tachi kura ni edomoshi because mo fia mo le ke wo ke bi a se fe mo fia mo la ke Akukor Foto jengbe fe
wo fe wole ake
wo fe wole ben no kata problem po ba jembe onu ni ade na de be Sempe ni kan government first
nakai
Sempe ni kan government first akefe farm ke ni bi jeme
yes
odu se wo ta many Sempe ke ha na mi no ni mi no amayu akeshi je Sempe no ni oda ni iwo ni efe to mo hiwa ko te ba ni emi ni ke wa lose guard awaye bo hiwa
that's right
awaye bo hiwa ni wo fe wole wo che akeke ibale Sempe small ke ni bi ele no le ewon ye mo odubichi wo fe ni te ma dabo shi ke ni bi no kan fe ni o ani mambi ele wo che nwe ebo to ke no ko ye de ka ba gbe yi ni wo ka support wo ke se nwe ibanye ke ha ko ni mambi fe aye odase mambi fe aye odase ni agbene nwe Gbawe bi na me ke abete je several times ni Sempe bi ka me na gidi fe mo mini evidence am yo ami boko nu ko na ka nu ko da ni tete moko ona ga shi ni ko me ni ka ko fa to be mi na mara mali one moko nu ko na ka nu ka ke Gbawe bi ete Sempe bi atpo na ke anu alo ata fe gidi nu ko moko nu ko da apart from the case na eba e wo mini ene wo am in critic and be ni afi to mo mini ona ni oda iwo won pa wo che fa ni wo fe wo ga Solomon appearance ni no fe ni yo ni ipa fita ni sani e ba ye mu ni eye mu ni $20 aba ko ni wo fe wo ya wo yin fa no manye bra
ya so chemege jeme benyele ene ni kan le mo fa so wo ga woni fe mo e ba na gbe wo ma ba bi ma fe Supreme Court no in appeals court and so ene na ejekwe Sempe stool ameke wa bi ameke te Supreme Court bona the Supreme Court ye so what mama can the no ni Supreme Court ke then it be an ameke te review ni like I said at the beginning of the show I call kwemi and get Supreme Court no I'm a ruler one side obana shi be pia ka at a review I'm no ga me check ya me dwomo bona ni review no the final stage so review na kan jame mo ko nye ka ma play don e go be na don review the final stage so I'm sure I can Sempe lawyer say I'm about gather my ammunition so you understand what I'm saying ni I'm a review ni I'm a like I said if me na ina ni obabia ke be me 5 any ba tami na me ba here one side there ka ke me yenyo ba fita me na me face 7 allo I get me 4 ba fita na me face 9 e ke be me 5 no e come no e chage amejomo yi amana mba ga uda bi money work well first je na kan ni won kwele ni so it can happen. The Sempe still they have a shot at having this thing in their favor. So what about no Supreme Court here? Like I said, what about a third show? What about can no ni Sempe ba ke other documents come any tomobeno na in ka kolache judgment the portion where ni it make it clear ake Sempe me she once again ani one hour ake a confer possessory rights to Sempe stool. You understand what I'm saying? In no ba chombo so makani akola che judgment ke chombo. There is another judgment between Tumobeni and Kebwe. The need and so no what can the last 2 years get the Sempe stool where ni na can no jeje unwe myake Akukor Foto no Sempe ma no makani no ma chombo. Eke what can the other document ko ni ake amie makani no ma habo. So we'll go deep into this. Koni record say I reflect no friend ni ojuma. Eko meko minda nyefenshi akenyekemi eyinshi ahunke batabiane tamaboni nyele. It is reading, it is boring, but we need to let everything go out there. So chemeka nyame oklejie ebu wofen woyi ni wo wosa wobakpe ye bie ekon ye esu mona nyeyi anawala da agbene we week na mi we ka yotwi we another mene afungbese manye we'll get into that as well. We'll try a longer version. Bits and pieces of it, but we'll play a longer version for you. So we'll do that as well for you. Bye bye.